there. Let me see how we doing. We should be back in the building. Good morning, y'all. Looking all crispy and clean on the screen. Welcome back to another YouTube live stream and another episode of the ClassE Morning Show. I'm your host, ClassE of patreon.com/ClassEbeats. By the way, link is in the description as well as in the pinned comment in the chat. Today we're going to get into it. We've got day 35. Oh my gosh. This Karen retrial. Maybe we'll have a verdict today, maybe not. I need to put a poll in the chat for you guys to see what y'all think and if we're going to have a verdict today, because my bet's already messed up. I thought we would have a verdict on Monday. I was absolutely wrong on that. We'll see today. I think it's been a total of 9 hours according to Law and Crime, but we'll get into it here in a second. Shout out to the gang. Before we get into it, I gotta say what's up to the people though. Shout out to everyone who's in here. You know, my awesome, amazing Amy is in the building. We've got CPE in here. Taco Tuesday. It's your day. We got Les Cleaver in the building. Kara Hampton, Slim Life, New Jersey. Jay Buckmaster is in here as well. Excuse me. Perfect Peace. Libby22SC Girl. Up in here, we got Virginia Wiley. Welcome to the Patreon as well, Virginia Wiley. I saw you joined over there. Appreciate you being on that side. We've also got Sassy and Free up in here. Okay, good to see you, Sassy and Free. We've got, who else is in the building? Shout out to all the members in here as well. I know I missed a couple of y'all. I said what's up to Slim Life. We got Penny Neal is back in the building. And we've got Valencia. Valencia, it's been a minute. Good to see you in here. Danny in real life. We've got Heiser fam is up in here as well. Thank y'all for being here. Shout out to the gang. You guys know I don't ask for much on this show, but there is one thing I ask, and that's that you guys like the video. Guys, likes are free. It really is one of the #1 ways you can help out this channel. It takes less than a second. It lets the algorithm know you guys are enjoying the show, and it shares the video, the channel, this live stream with more people. So if you guys could take a second and do that, I would greatly appreciate it. And thank y'all for the support. I'll be saying what's up and good morning to y'all as we go throughout the show as well. All right, and shout out to Keely for the morning show song as well. All right, so let me see. So yesterday we got into a little bit of testimony from Colin Albert, and man, we did some rewind. That testimony was garbage. This kid's clearly lying, hiding something. He can't remember anything and everything at the same time. I don't know how that works. So we're gonna move on from Colin Albert. It really wasn't much there, and we're actually gonna get into Michael Proctor. Now I'm gonna try and weigh out, and you first trial watchers, let me know when you think a good stopping point would be for his direct, because I definitely want to make sure we get into cross-examination for Michael Proctor today at some point. So let me know, because his direct testimony, I think I looked at it, it was around, I want to say 3 to 4 hours or so. And then cross-examination starts right after that. So you first trial watchers, let me know if there's a good stopping point. I think we could probably feel it out and see, but we're going to get into Michael Proctor's first testimony today. Lady E is in here too. Shout out to Lady E. And also, I got to acknowledge the super chats. First of all, thank you to everyone, all 600 plus, nearly 700 of you that liked the video. Thank y'all for the support. And I gotta shout out everyone who went the extra mile and super chat as well. I will be reading super chats throughout the show. We've got CPE in here with the 5 bombs, just showing love. Thank you, CPE. Always showing up and consistently supporting as well. Shout out to my guy. We got Les Cleaver in here with the 5 bombs. Says happy Taco Tuesday. And praying for acquittal. All taxes paid. Bless everyone. Stay cool. Be loved. Take a moment for yourself and just breathe. It makes me want to start singing that song about you when you breathe, but I won't sing on the morning show. It's too early for that. Thank you, Les. We got Kara Hampton in here with the 5 bomb as well. Said it's Taco Tuesday. I hope everyone enjoyed their evening/night. May we reset and have a great day on purpose. Yes. Let's get this not guilty, taxes paid. And shout out to Kara, always reminding us to have a great day on purpose. Guys, it's up to us. We get to control it. And you really have to be purposeful about every single day. I'm working on it. I'm not perfect about it either, but we're getting there. Thank you for the reminder, Kara. We've got Slim Life New Jersey in here at the 5 bomb. Says, good morning, ClassE, Amy, and my CEB family. I hope everyone has a blessed day. And remember, God is good all the time, and all the time, God is good. Amen. Make good choices. Don't drink and drive. No OUIs, no DWIs. Okay, we're better than that out here. Love you all, and free Karen Reed. And we got Virginia Wiley in here as well. Just became a member over on the Patreon. Y'all want to check out the Patreon like Virginia Wiley? Make sure you click the link in the description as well as in the pinned comment in the chat. And she says, good morning, CEB family. Let's start today with positivity and be the difference. Love y'all. Be great. Thank you so much, Virginia Wiley. And then Amy, you know she does not miss coming through with the 5 memberships. If you got a membership from Amy, make sure that you say thank you. She shows up here every single day and has been helping out and contributing to this show for a long time. So thank you, Amy, for all that you do. Thank you for being here every single day, interacting, engaging, contributing in so many ways, giving great insight. I mean, just all around value. The value that Amy brings to this channel is amazing. So big shout out to the awesome, amazing Amy. All right, we'll go ahead and get into it. I'm going to read a couple comments, and I also have to put in the chat for you guys on when you think there will be a verdict. And actually, I'm going to make this easy on you. Will there be a verdict today? Because going past Monday was honestly a shocker for me. I did not think this was going to go past Monday. I knew Friday it wasn't going to happen. Monday, you've got the whole day to figure out and go back and forth on what's going on. So when you guys respond, let me know. If you say yes, let me know what you think the reason there will be a verdict today, or why you think there will be a verdict today. Excuse me. If you say no, let me know why you think there's been a holdup or what the holdup is. All right, so I want to hear from y'all. Let me know what you think. Dottie is in here finally. I can't start the show without saying good morning to Dottie. Shout out to the greatest Dottie in the world. Good to see you in here. I love you. Thank you for being here, and good morning. Shout out to Dottie. Who else? Did I miss anybody else? I know there's a bunch of y'all in here. Gemini Rising, Shayna, Shauna. We got Unique is in here. James is in the building too. I saw, let me see. Yeah, and Dominique Carter says, you're amazing, Amy. Thank you for all you do. You also have an amazing channel as well. Oh, if y'all haven't, I need to tell you guys about this more often. If you haven't checked out Amy's channel, the content she puts on her channel is amazing. And I'm not just saying that. Like, you can sit there and watch those videos for hours. So if y'all haven't checked out her content yet, make sure you do that. I dropped the link in the description. And you know what? Actually, y'all know about the Patreon. I'm going to put that in the pinned comment as well. Go show her some love. Go support, subscribe, and check out all of her videos. All right. Jake's in the building. What's up, Jake? The holdup is the OWI charge. Just charge her with the OWI. She was drinking. She was driving. She has to. Yes, I agree that while I agree this trial has taken a toll on Karen and she suffered a lot because of this, she messed up there. And to think of what I said, if no one had been drinking that night, imagine how differently things would have went. Not only for Karen, not only for Carrie, not only for Allison, but for John O'Keefe too. No, slap that thing on her. I'm not mad about it at all. In my professional opinion, says Jonathan Devereaux, one of the dopest names I've ever heard, just like the 4 doctors that testified, John O'Keefe was not hit by an SUV. There's no, he has no injuries consistent with the collision. Makes sense. I agree the OUI is likely holding them up. That's an interesting take. So what do you think is holding them up? Because again, as we read yesterday, and I'll go back in and cover this. Where did it go? Albert dates. So Karen, when she went to the hospital, her BAC was at 0.93, which is already over the legal driving limit. So what's the holdup? You guys have to let me know what the holdup is. Shout out to Lady Ian here. Apparently on another channel, it is said that the lady jurors are all dressed up. So today might be the day. That's some good insight. Let's get Karen free from this corruption Crazy ride to watch you all. Amy says, I'm about to hit 30K. I can't even believe it. Shout out to Amy for growing the channel. Let's give her a round of applause for that. Can y'all go over there and subscribe to Amy's channel and get her up to 30K today? I think we can do it. Amy says, thank you for helping me, encourage me to do it, and all the things you taught me, class. Now, Amy, you put in the work, so you're welcome, but it's minuscule to the work that you had to put in. So that's all you. I agree. OUI. They have her interviews talking about all the drinks they had. I want her free and clear, but those clips aren't helping. Yeah, and the fact that she was at .039 or .093. That's fine. They can get, the jury can say that they gave her the OUI. Getting worried. I thought they would have a verdict by now. I'm thinking guilty on some count. Probably the drunk driving. Yes. And the men are all wearing sneakers. What else is new? Yes, but they charged her with murder for something they did. 3 years and 5 million. No OWI because the rest have not been charged. Sorry, but not totally what I would normally vote. Well, I mean, maybe that's a separate thing. If somebody wants to charge them, they can, but they're focusing on Karen Reed right now. They can't prove that that was her blood or her BAC that night, though. She drank after she got back to the house. That might be confusing to them. Guys, I get the technicalities and I get the BAC. But Karen was acting completely reckless for a 40-something-year-old woman. There's no reason that she should have been drinking and then gone and drive. If you have one drink, don't drive. I'm not a fan of it. I don't think it's okay. I get the law is the law. But for me personally, as I said yesterday to y'all, I have a personal vendetta against driving after drinking. And yeah, I've seen enough. I saw her at the waterfall drinking and driving. She said multiple times through text to John throughout that day that she was going to go drink. She drove then. We got to stop this at some point. Karen can say she drank when she got home out of stress. She was drinking way before that. Y'all don't forget. She said at 3 o'clock or something, she was going out to get drinks. Oh, man. How is this verdict taking so long? There is so much doubt in this case, and that's all that is needed. The American justice system is on display around the world. I heard somebody said something the other day, and I think I might tend to agree. They said, I'm realizing more and more that we don't have a justice system. We have a legal system. And in a lot of cases, that's true. I mean, justice... Think about, let's do a little bit of a rewind and go back to YSL, right? So many factors about that RICO are not just. One, the fact that this man who, yeah, he had some guns. Yeah, he had some drugs. He wasn't dealing the drugs. He was surrounded by some of the wrong people. The fact that he's able, Young Thug, Jeffrey Williams, is able to get a RICO slapped on him is just egregious at this point. He's a music artist. He made some bad decisions. Should not have a RICO, right? It's the legal system. It's the law. Then you have a guy, Yak Gotti. Made some rap music, said some things, took some crazy pictures, hung around with certain people. And he was at the wrong place at the wrong time, connected to the wrong people. And he sits in jail. He gets stabbed. Sits in there longer than any defendant, than most of the defendants had. Is found not guilty on all counts, and he still has to be in jail because of something that happened while he was in jail for charges that he was found not guilty on. That's a legal system. That's not a just system. That's not just. Then on top of all that, you've got Shamel Drinks. He's gone. We don't know what happened to him. We've got Donovan Thomas. He's gone. We don't know what happened to him. We have police and we have these humans that are out here making mistakes. They're disregarding the car that pulled up and most likely was the one that shot this poor guy at a stoplight because they wanted to identify and lock in on Shannon Stillwell and whoever else they thought was in the car. I think saying it's a justice system at this point is, we've seen too much, guys. We've seen too much with just the few trials that we've covered here. I don't know that we can call it a justice system anymore. Sometimes it gets it right, but a lot of times, especially when it comes to indictments, it's the farthest thing away from just. Anyway, I'll get off my soapbox. I know y'all want to get to the videos. I'm tired of me talking. You don't convict somebody on their behavior. You can convict them on the evidence. Well, there's tons of video of Karen drinking and getting in the car, so I don't need much. I don't need to see anything else. There's not much I need to see. If you want to get into the technicalities of it, fine. But I saw her drinking. I saw her taking shots. And then she got in the car and drove. And she confessed to that on camera multiple times. Get her out of here. We've got Amanda Strong in here with the 2 bomb. Thank you, Amanda. And that's her first super chat. Thank you for sending that super chat, Amanda. And thank you for stopping by and supporting the show. She said, wait for it. I know I've been talking a lot this morning, y'all. We'll get into it. What do you think John's mom is thinking now? Do you think she still wants to kill Karen, or do you think her thinking is changing due to the corruption of evidence? She's already had her mind made up, and you guys saw and we heard evidence from Carrie and from Jen about how Peggy felt about Karen. She did not like Karen. She didn't like Karen from the beginning. Karen came to the hospital. She said, "What's she's doing here?" So I can't imagine Peggy's changed her mind on that. I agree. She got wasted after she got home. That is the only reason her blood alcohol content was so high. They can't prove that she didn't. That's true. She didn't admit to drinking later. I'm just saying it is possible to have, in order to have her BAC at 0.09, if she didn't drink at home, then she was straight hammered to have BAC that high 4 hours later. Everyone in Canton obviously drinks and drives, allegedly. I don't think it's alleged. I think they unashamedly drive drunk. Peggy is delusional. Yeah. And then what else do we say? ClassE, we get she was drinking and drove afterwards. John was not hit by the vehicle. What's the reason for the operating a vehicle under the influence? We get she was drinking and drove afterwards. John was not hit by the vehicle. Oh, I see what you're seeing. What's the reason for? Oh, you're saying why are they charging her with that? Because they can. Why did Fannie Willis charge Young Thug with the RICO? Because she's thin. You said, hey, you know what? Let's add this to the verdict form. There's some evidence of her drinking. We could probably prove beyond a reasonable doubt. Reasonable doubt, again, guys. I'm going to switch. I'm going to go to the other side here, the prosecutor's side. Is there, beyond a reasonable doubt, do you believe that Karen Reed was drunk when she was driving? I happen to believe yes. So the prosecution looks at that and they say, oh, we can get an OUI charge on here. We can get a DWI charge. Let's throw it on there. You know what? Did she make an illegal U-turn? Let's put that on there too. And it's because they can. You know, they're all about getting convictions. So if they can get a conviction out of this, it's a win. Hi, Karen is guilty of DUI, but John's death, and that is unrelated, I believe. I agree. The mom's mindset is set in concrete. She will never believe anything else. To do so, she would have to believe all the people she knows, surrounds herself with, are liars, which they are. Wow. You don't think the blue paint change Peggy's mind? I don't think so either. They all need to be charged. I agree. She was drunk when she was driving. She probably does it every day, just like so many in that area. It seems like. Did Karen wear white after Labor Day? Put it on the verdict slip. Yep, CPE knows what's up. That should be a charge. All right, y'all are sick of me talking. Let's go ahead and get into the content. Again, thank you to all 700 of you who are in here. Thank you to all 700 of you that liked the video. If y'all could take a second, like the video. Let's get some hear ye up in here, and then we'll start with Michael Proctor. She's ready. Let's get it. Come on. Let's hear the hear ye. And this is today.
Hear ye.
There it is.
All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, hold it in Dedham, within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anybody since we met yesterday? Everyone said yes or not.
Lies.
Was everyone able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no. So, Mr. Foreman, with that, we're going to send you back out to deliberate.
All right, please.
Jimmy?
They lie. As a forensic scientist, it was really frustrating to watch this trial. I can imagine. As someone with common sense, it was really frustrating to watch this trial. So, yeah. I can imagine as a forensic scientist, that would be tough. Oh, look at Karen with the green. Okay, that might be her color. Karen rocking the green today. Shout out to the Boston Celtics. They got eliminated.
So,
prayers out for Jason Tatum.
I've been sending a note in at 4 o'clock, so I would like
you,
counsel
Amy.
here at 4 o'clock. All right, so if you just plan on being here at 4 o'clock, it would make it easier in case the jurors want to go home. So, all right,
you know they're
Ms.
watching.
Giannetti, it wasn't until I was here that I noticed you were not in the courtroom.
They held me downstairs, Your Honor. I think the jury was being brought in, so.
Okay. No one told us otherwise either. So.
Understood.
All right, thank you.
All right. Let's see the recess to exit court.
Yannetti just left to show up. And now he's going to leave. All right, so let me double check and make sure we don't have any other happenings going on here. Let's see. No, we'll skip ahead. Skip ahead. Okay. I think we're good. So what we're going to do is we'll get into Proctor here. I've got a couple more super chats that we're going to cover, and then we'll see what Michael Proctor had to say. You know they're watching. But I like that you went in with an open mind and not biased. I was not biased at all. I did not know what this case was about. And I honestly considered not covering it, but y'all know how convincing you guys are. Speaking of, what should we cover next? What do you guys want to see next? We've got YNW Melly coming up later on this year. We've got the Naziah Harris trial. Very invested in that one. So we will be covering that because we've already seen enough evidence in the preliminary hearings. I want to see that guy buried underneath the jail, Jarvis Butts. But from a legal standpoint, it's going to be interesting because we don't have a body and we really don't know what happened. He could be buried under the jail from some of the other things that were covered during preliminary hearing. But when it comes to Naziah, that's going to be interesting there. So let me know in the comments and in the chat what trial you guys want me to cover next. I know, actually, I saw Kathy from Law and Crime said there was a trial starting today. That's going to be interesting. Carmela Anthony when it starts. Ooh, that would be a good one. We got Brian Koberger. I don't know which one that is. I gotta write that one down. I don't know who Brian Koberger is. Yep, we'll cover Nazaya. Don't worry. Don't worry. We have to keep our eye on Mickey Steen trial out of Kentucky. How about Megan Jackson? Okay, you got Megan Jackson. Yep, you know we'll be covering Melia and Jarvis over there. Idaho College. Yeah, I think, is that the one that started today? Has opening statements. Kathy mentioned that one. Maybe we'll jump over there and see what that's about. Over on Law and Crime. Shout out to Amy with the 5-bomb. Says you can't always have a good day, but you can always face a bad day with a good attitude. Yes. And when you got an Amy around, it makes the bad days a lot easier. Shout out to Amy. I appreciate you. Thank you for the super chat. We've also got Dominique Carter in here with the 2-bomb. No comment, just showing love. Thank you, Dominique. Also, Paula is in here, says, Amy, I'm going to clip that for my office. Perfect start to my morning. Yeah, that's a great quote. I got a list all of a sudden. Idaho Murders. No, that's Brian Koberger. Oh, okay. So that's the Idaho. Okay, got you. Koberger is going to be a very lengthy, tiresome trial. He's the suspect entailing the life of 4 young students. I'm totally going to be glued to that one. Okay. Interesting. We'll have to check that out, man. I will see what's going on with Brian. DoorDash driver in Koberger case expected to testify at trial. She saw Brian. Ooh. Interesting. And when does that case start? Do you guys know? Wait. You saw that? Okay, all right. So we'll have to check out Brian Koberger then, if y'all are saying. Let me know again in the comments and in the chat which trial y'all want to see next, because you know we're going to be covering some. It starts on August 11th. All right, let's go ahead. Y'all ready? We're going to do a little bit of a rewind, and we're going to see what Michael Proctor had to say when he took the stand. Now, you guys know Michael Proctor, the disgraced former trooper Michael Proctor, was up in here doing some wild and crazy stuff, sending crazy text messages to a group chat. It was being liked by his boss's boss. I mean, taking evidence from a solo cup and riding around with John O'Keefe's clothes for about a month and some change. This guy's a mess. I'll be interested to hear his direct testimony. Again, if y'all think we're at a good stopping point on direct, if you've heard enough of his BS, we'll go right into cross-examination. So I'm going to let you guys help control this segment of the show. Let me know what y'all think. Here we go. Michael Proctor.
Next witness, please.
We'll go ahead and start this off the right way, by the way.
Call Trooper Michael Proctor to the stand.
There we go. Call Michael Porter Potty. It's embarrassing. Look at him with his evidence bag.
Raise your right hand. You solemnly swear the evidence given to the court and jury in the case now hearing to be the truth, the whole truth, and nothing but the truth.
Good morning, Your Honor. Good morning, jurors.
Thank you for being here, Chris.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Good morning, sir.
Would you please state your name and spell your last name for the jury?
Trooper Michael Proctor, Proctor.
And how are you employed, sir?
I am currently assigned to the Norfolk County District Attorney's Office in the Homicide Unit within the Massachusetts State Police.
Wait a second. Did he say he was what now?
And how are you employed, sir?
I am currently assigned to the Norfolk County.
Whoa. So he got fired during the trial? Hold on a second. I did not know this. Again, y'all, I didn't watch the first trial, and we didn't hear from Michael Proctor during this second trial. So when was he fired? That's wild. Oh, this makes this even crazier. Michael Proctor, lead investigator in Karen Reed case, fired from Massachusetts State Police after vulgar text, and among other things. Proctor was suspended, without pay after Karen Reed's murder trial last summer. When was he fired? Massachusetts State Police investigator who was suspended over allegations of misconduct in the Karen Reed murder case has been fired, state law enforcement officials said Wednesday. So he was fired this year? Dang. The State Police Trial Board made the decision to dishonorably discharge Michael Proctor, who led the investigation in 2022, death of John O'Keefe. When was he suspended, though? The trial board found Proctor guilty of 3 charges of unsatisfactory performance and 1 charge of consumption of alcohol while on duty. What? Oh my gosh. From January to August of 2022. So while he was performing this investigation, the charges stem from Proctor's sending derogatory, defamatory, disparaging, and otherwise inappropriate text messages about a suspect in an investigation to other individuals. Proctor also consumed alcohol on duty and proceeded to operate his department-issued cruiser in July of 2022. Jesus. This doesn't tell me when he was actually fired, though. I'm going to find out. I'm going to find out when he was actually fired. Guys, this is insane.
County District Attorney's Office in the Homicide Unit within the Massachusetts State Police.
And how long have
Trooper, I'm going to ask you to keep your voice up loud, okay?
Yes, ma'am.
Thank you.
And sir, if you want, that microphone in front of you is adjustable, so how close or far away you want.
This is crazy.
How long have you been a trooper with the state police?
For over 10 years, and it'll be
Massachusetts.
5 years in September with the Homicide Unit.
Now, with
He was
reference to
March 19th
your
of this
work
year.
with the homicide unit, with the detective unit.
So Michael Proctor, the lead investigator in Karen Reed case, was officially fired by the Massachusetts State Police at Massachusetts on March 19th, 2025. So he was just fired a few months ago. When was he suspended? Was he suspended after the trial or during the trial? He was suspended July 8th, 2024, following a state police duty status hearing, a decision that took effect immediately the same day. Wow. And he was suspended without pay. They got him up out of there. So it was right after the trial. Jeez. That's embarrassing.
What, if any, specialized training did you receive in regard to your work within that unit?
Wow.
I've attended several homicide schools. I've also been certified in Celebrite software programming. I've also, in addition to homicide investigations, have worked within the narcotics unit on several different investigations there as well.
Now, with respect to your work with the detective unit, as far as, do you have sort of an on-call system?
We do.
And can you explain to the jury sort of how that works, or how those specific days for your on-call duties are assigned?
Sure. So a Sergeant Buchanan usually sets the on-call rotation. It's at random, and your on-call is from 7 a.m. to 7 a.m. Any unattended death, homicide, suicide, overdose, things of that nature that comes in during that time frame, you own it. That's your call.
Now, were you working in that capacity with the
Disgusting,
detective unit on January 29th, 2022?
Yes.
And at some point in the morning, did you receive a call in regard to a situation in the town of Canton?
I did.
And what, if anything, was that? When did you first receive that call? You know?
Sergeant Buchanan called me at approximately 6:48 that Saturday morning, advised that Canton PD had a male party that was discovered in the snow outside of a residence, and he wasn't sure what had happened. It was originally given to me as a possible medical situation.
And based on that initial call and that initial information that you received, what, if anything, did you do?
At that point, I knew I needed to gather further information, so I contacted Detective Lank from Canton Police Department to see exactly what transpired in the morning. He had informed me that a male party had been transported to Good Samaritan Hospital with some injuries. Detective Lank didn't have much more information, so I knew I needed to contact the paramedic at the hospital, the individual who's treating Mr. O'Keefe.
Now, before we get to that, if I could, I'm sorry. As far as Detective Sergeant Lank was concerned, was that someone that you called on your own, or how did you get his information, or why did you call him specifically?
I knew he was on scene, so I called Detective Lank.
Thank you
So that
for
was some
that.
information that you had received at some point earlier, and then you contacted Detective Sergeant Lank.
Correct.
Yeah.
And following that, you reached out to whom? I'm sorry.
This firefighter Anthony Flamati.
And with reference to that conversation, what, if anything, did you learn from that?
Firefighter Flamati informed me that
I'm going to allow it.
Mr. O'Keefe had some injuries to his right arm, some abrasions to his right arm, some injuries to his eyes, a cut to the nose area, and he put a 10% chance of survival for Mr. O'Keefe.
And then based on that information, who did you call next?
I contacted Sergeant Buchanan, advised him that this sounds like it's more than a medical situation.
And what, if any, decision did you and Sergeant Buchanan come to with regard to what to do or where to go or what the next step should be?
So there was a couple different steps. Number one, it was blizzard conditions, and we operate, Ford Fusions or Chevy Malibu. So we got authorization to use our personal vehicles that are four-wheel drive, and to meet at Canton PD and to speak with the responding
You say so,
officers.
Libby.
And about what time was it that you and Sergeant Buchanan arrived at the Canton Police Department?
It was approximately 10 a.m. that morning.
And so, Trooper Proctor, if I could ask you, whereabouts were you at about 8:22 in the morning?
Home.
Had you shoveled out of your driveway at that time?
Not yet.
Had you cleaned off your car at that time?
No.
So you arrived at the Canton Police Station about 10 a.m. or so. When was it that you arrived in relation to Sergeant Buchanan, if you know?
At Canton PD?
Yes.
I don't recall if Sergeant Buchanan arrived first or myself.
But suffice it to say, at some time you both arrived around 10 a.m., is that correct?
Yes, sir.
And where did you go with the Canton Police when you arrived there?
We spoke with the Sergeant Sean Good.
And what, if anything, did you learn from Sergeant Good?
Sergeant Good informed us that while he was on scene, he identified Kerry Roberts, Jennifer McCabe, Karen Reed. He also informed us that Jennifer McCabe was out early in the night at a waterfall bar in Canton with some individuals, and that she was the one who called 911 when they found Mr. O'Keefe in the snow that morning.
And remember, this was the testimony and the investigation that Yuri said was done with integrity. Okay.
Now, with regard to the parties that you just mentioned, prior to January 29th, 2022, had you ever met or were you aware of either Jennifer McCabe or Kerry Roberts, or Karen Reed, or John O'Keefe?
I've never met any of them.
And at some point subsequent, did you have occasion to meet and speak with Ms. Reed?
Yes,
And do you see Ms. Reed in the courtroom today?
I do.
Just for clarification purposes, if you could identify as to where she's seated or an article of clothing that she's wearing.
She's seated between Mr. Jackson and Mr. Yannetti wearing a pinstripe sport coat.
Just ask a record reflect identification of the defendant.
Yes.
Now, after you speak with Sergeant Good, did you speak with anybody else at the Canton Police Station?
No.
And where did yourself and Sergeant Buchanan go from there?
We then traveled to the home of Matthew and Jennifer McCabe.
Now, with reference to when I say you and Sergeant Buchanan, at how long a period of time was it that you were with Sergeant Buchanan on that date of January 29th?
And that's Yuri.
It's from 10 a.m. approximately when we met at Canton Police Department until when we returned to the Canton Police Department that afternoon around 5:30 in the afternoon. So all day. And we also had a debrief meeting with just the troopers in my office at Canton PD. So at least from 10 to 6, 7, because we also went back to the office with some evidence.
And so from that entire time, from 10 in the morning until later on in the night, other than maybe short drives in individual cars, were you essentially with Sergeant Buchanan that entire day?
Yes, we used Sergeant Buchanan's pickup truck that entire day. I left my personal vehicle at the police department, and I rode with Sergeant Buchanan all day and into the evening.
Now, from the Canton Police Station, where did you and Sergeant Buchanan go?
The McCabe's house in Canton.
And who, if anyone, did you speak with there?
We spoke with Matthew and Jennifer McCabe, as well as Brian Albert.
And those interviews that you conducted, were they how were they conducted?
One-on-one, Sergeant Buchanan and myself kind of rotated out Jennifer, Matthew, and Brian. So first we interviewed Jennifer, and then once that was completed, we had her step out, go to a separate room, brought in Matthew, and then the same thing with Brian.
And for the balance of the interviews that you conducted several interviews over the course of your investigation in this case, is that correct?
Correct.
And for those interviews, as far as individually done, was that primarily what you did with each of the people that you interviewed over the course of the investigation?
Yes, each interview conducted was either with Sergeant Buchanan or another trooper, in one-on-one, with the exception of Julie and Chris Albert, I believe, were in the same room as us.
Now, with respect to, I believe you just answered it, but as far as each of the interviews that you conducted over the course of your investigation, was it at any point in time was there an interview that you conducted just by yourself?
There was just one.
And who was that one that you conducted by yourself?
That took place just at the grand jury across the street. It was the Currans. I had some difficulty locating them, so when they appeared for grand jury, I interviewed them one-on-one by myself prior to their testimony at grand jury.
You had attempted to meet with them prior to them coming to the grand jury, is that correct?
Yes.
And they had not been responsive to that?
Correct.
However, they were responsive to the summons, and so you interviewed them before they went into the grand jury, correct?
Yes.
Okay. Other than those, as far as Mr. and Mrs. Curran, every interview that you conducted was in the presence of at least one other trooper?
Correct.
Now, as far
So
as
other
you
than
mentioned
that-
one name that we hadn't discussed before at the McCabe household,
Let's see if I
a
can
Brian
find the
Allen.
text
Prior to
message.
January 29th, 2022, had you ever met or were you aware or did you know Brian Allen?
And I met Brian Albert until that interview.
Now, following the interviews that you conducted at the McCabe household, where did you go from there?
After the interviews at the McCabe household, Sergeant Buchanan and I traveled to Good Samaritan Hospital for two reasons. One, we knew Miss Reed was there receiving treatment for Section 12. And two, we wanted to view Mr. O'Keefe.
And when you arrived at the Good Samaritan Hospital, was the defendant, Miss Reed, still at that facility at that time?
We had spoke with the security staff at Good Samaritan Hospital. They informed us that Miss Reed was released,
I'll allow it, just as to where you went.
that Miss Reed was released several hours prior to our arrival.
And do you know about what time it was that you arrived, yourself and Sergeant Buchanan, at the Good Samaritan?
Maybe approximately 1 o'clock.
And you mentioned there was a second reason, and that was to view Mr. O'Keefe, correct?
That's correct.
And did you have occasion, or did you have a chance to view Mr. O'Keefe's body at the Good Samaritan?
We did.
And where was that within the hospital?
That was in the emergency room.
And when you went to where Mr. O'Keefe was, can you describe for the jury what, if any, observations you made of Mr. O'Keefe's body at the time that you observed it?
The first thing I noticed on Mr. O'Keefe is he had abrasions on his right arm. On the top of his right arm, there's approximately 6 to 8, ranging from his forearm to his lower bicep. There was no injuries underneath that forearm. Both eyes were swollen and black and blue. He had a cut on, I believe it was his right nostril. Another smaller cut, I believe it was on his left eye. Those were the injuries that kind of jumped out to me.
At any point in time, did you make any observations of the back of Mr. O'Keefe's head while you were there?
I did observe blood on the back of the head. I wasn't able to tell if there's any significant trauma to the back of his head.
Now, from the Good Samaritan Hospital, yourself and Sergeant Buchanan, what, if any, items did you secure in evidence from the Good Samaritan Hospital?
So after we viewed Mr. O'Keefe's body, we observed a pile of clothes in the corner that hospital staff had cut off Mr. O'Keefe and kind of piled into the corner. The one thing that had jumped out to both of us was one sneaker. And it's fairly common in a motor vehicle pedestrian strike that
Sustained. Next question. I'll strike them
Objection,
fairly
Your
hard.
Honor.
The observations. will remain.
As far as the clothing that you observed, can you describe the clothing that you observed?
Yes. We observed one black sneaker with the Nike logo, a pair of blue jeans, a belt, boxer shorts, an orange T-shirt, and a two-tone gray, light kind of hooded sweatshirt type of material.
Now, Trooper Proctor, over the course of your career responding to unattended deaths or death investigations as a member, as a detective of the unit, how many of those have involved situations where a pedestrian was struck by a motor vehicle?
Well, I've been in the unit, maybe 3 or 4, and then I've other experiences on the road.
And as far as the other experiences on the road, can you expound upon those as far as how many or over what time period we're talking about?
About 6 years I spent on the road, so maybe another 3 or 4.
And with reference to those pedestrian crashes, what, if anything, had you seen in those prior investigations in regard to sneakers or footwear of pedestrians involved in motor vehicle crashes?
I'm going to see you at sidebar on this.
No, they had to go to a sidebar. Dang. All right, we know about this investigation. Let's maybe. Ooh, they actually get into some video evidence. Let's skip a little bit ahead here. And y'all first trialers have to let me know if there's
The
any
chemist with removing the
key testimony that we need to focus on here.
housing unit.
Now, at any point in time on that day of February 1st, 2022,
Sidebar.
did you come into contact physically or otherwise with that tail light? Did you handle it in any way, shape, or form?
No.
Your Honor, if I may, with the court's permission, I would request to publish. Give me one moment, Your Honor. If I may have one moment, Your Honor.
Yes.
My apologies, Your Honor. Video.
Here we go.
Ms. Gilman, if I could have from February 1st, 2022. At approximately 9:12 a.m.
This is a Sallyport video that got flipped.
You can just pause it right there. Okay. Your Honor, if I may, it may be easier and more visible with this particular video with the lights on.
Okay.
Try that.
Good
Sure.
morning, y'all.
Trooper Proctor, directing your attention to what's up on the screen is Exhibit 34. Do you recognize what's depicted on the screen?
Yes, that's the Sallyport area, Canton Police Department, and Miss Reed's Lexus kind of roped off with yellow caution tape.
And this is
Nasty
the execution
work. You knew
after
what it
one
was
that you were
doing.
speaking about before as far as your presence and some of the other members of the state police and the state police lab that you were talking about.
Correct.
And Ms. Gilman, if you could run from here for just a few minutes. And sir, while this is going, if I could just ask a couple questions as far as people within this video, do you recognize anyone in this video?
Yeah, myself, kind of the top of the screen. Trooper Zach Clark, we're the one with the camera taking photographs of the vehicle.
Now, with reference to this video from the Sallyport Garage of the Canton Police Department, what, if anything, did you learn over the course of this in regard to how that video is reported or how it's, what, if anything, sort of activates that video?
Objection.
Ask it differently, Mr. Riley.
As far as this video is concerned, is this one continuous time frame that we're looking at, or how is it?
Objection.
Sustained.
My understanding, it's motion
That
active.
means you can't answer.
Oh, I'm sorry.
You can ask a different.
You
I'm
know
not sure
that,
there's
Michael
anything
Proctor.
said.
Come on, man.
All right. I'll strike if there was anything. But Mr. Lally, just ask a question, please.
With respect to this video, as far as the recording is set up, how is that activated, or how does it record?
Objection. Same question.
Thank you,
Yeah,
Vintage.
how does he know that? It was sustained.
Have you watched this video or other videos from
Dang,
the Kansas
Lally
Police
is
Department
getting-
Sally Port Garage?
Getting
Yes.
killed by Bev.
What, if anything, did you note with regard to timing as far, there is timestamp on the video, is that correct?
Yes.
What, if anything, did you note with regard to the timestamp on this video or the other videos that you observed with regard to how time moved throughout the video?
The timestamp on the video tends to pause, indicating it's motion activated.
It tends to pause. I'll strike after that.
Come on, man.
It's going to run to about 9:24.
Is the tail light broken?
Ms. Gummy, you can take that down. Thank you very much.
Some of them are, D.
Now, Trooper, with regard to that tail light that was then taken by Ms. Hartnett to the lab, is that correct?
Yes.
And at some point, that was returned to the custody of the state police, your detective unit.
Correct.
And do you have that tail light housing with you today in court?
I do.
And, Your Honor, with the court's permission, if the trooper could retrieve that.
Okay?
May I approach, Your Honor?
Yes.
Probably be easier that way. Sir, you can stay right there. Handing you an item, sir. Do you recognize that?
Yes.
And what do you recognize that?
That's the. I recognize that to be the housing unit.
And as far as your recognizing of the housing unit, is there any sort of denotation or anything on the outside of that box indicating what's contained therein?
There's a State Police Crime Lab sticker with a number associated with it. It also indicates fragile and evidence tape that is initialed and dated as well when it's sealed up. And it's, the sticker also says passenger side TA, indicating tail light.
Thank you, sir. Your Honor, with the court's permission, I would seek to admit and introduce that as the next exhibit.
Do you want it out of the box first, Mr. Jackson?
We could just take a quick look at
Sure.
it. Sure.
With the court's permission, if the
Yes.
Oh, this is the worst part for me when they open the evidence boxes, especially a crooked a crooked trooper like this guy. Disgusting. I do. It makes me. I feel like it's being violated. Jeez. Oh, there's the tail light, the infamous tail light. Good morning, in blue.
And Trooper, you can go ahead and put that back in the box. Thank you very much.
it on the bag. We need to mark that, and we're going to mark it twice, folks. We're going to mark the bag within the box, and we'll mark the box as well.
They don't care.
They will both be 544. Thank you. Nancy.
I'm sorry, Trooper, if you could hand that to Madam Clerk.
Sorry, hold on. Hold on. So it's going to be 544 and 544A.
You know what I mean? Inquire. It was the A, the light, and the 44 is the bag.
We're not even putting it right on the light because it's broken.
Understood.
So we're putting 544 on the bag, 544A on the box.
Understood. Thank you.
What are we voting?
Could you put that on the bag, please, sir?
All right, here we go.
Okay.
We're gonna skip ahead a little bit. Mock. We mock it, not mock. We mock it. M-A-H-K. Mock.
Trooper Proctor, with regard to this ring video, how was this obtained, if you know?
So we first observed it through Mr. O'Keefe's cell phone on the Ring app, and then I wrote a search warrant
There you
for
go.
Ring itself.
Mock.
And as far as the videos that you received from Ring,
Good morning,
did they
Mr.
match what was on the, or what was viewable being the Ring app on Mr. O'Keefe's cell phone?
The videos on Mr. O'Keefe's app, yes, they was what Ring produced, matched.
So as far as any videos that were present that you received pursuant to the search warrant, or any videos that were not present, that was consistent with what you observed on Mr. O'Keefe's app on his phone?
Yes.
Now, Ms. Gilman, if you could press play through here. Now, Trooper Proctor, with regard to this video, you've seen this before, is that correct?
Yes.
Now, at the point from this video, are you able to discern who the operator of that vehicle is?
Based off the attire, Miss Reed driving.
Wow, you can
Now,
see all that.
with respect to when that vehicle, the defendant's vehicle, if you could, there's a laser pointer up there in front of you on the desk. If you could, I would just ask you to draw the jury's attention to what, if any, vehicles you observe in this video and whose vehicles you believe them to be.
So right there, it's Mr. O'Keefe's vehicle and Miss Reed's vehicle.
Now, as far as when those vehicles come close or come into contact with each other, as far as Mr. O'Keefe's vehicle is concerned, what, if anything, do you observe like on Mr. O'Keefe's vehicle at the time?
There's some snow you can see on the back window here, the bumper and the windows here is starting to be covered in snow.
Shout out to
And
Amy
as
with
far
the
as
cake.
when that vehicle comes close to or makes contact with Mr. O'Keefe's vehicle, what, if anything, do you observe the snow to come off of the car at that point?
I do not know.
Now, with reference to the back area of Mr. O'Keefe's vehicle, specifically in the area of the ground, as far as that area on the ground, what, if anything, did you observe in reference to any red pieces or any pieces of taillight or plastic or glass or anything in that area that you observed on this video?
So this area here is, you can see the white snow. There's no red pieces of taillight, which would show up in the contrast of the white snow.
Please tell me if you could run it from there for a moment. Now, as far as the damage area
morning,
that you were
Bill.
discussing previous that you observed in the January 29th in the Sally Port, February 1st in the Sally Port, and then the item that was just marked as evidence, what, if anything, do you observe in the right rear passenger side taillight area of the defendant's vehicle from this video?
You can see the inconsistent lighting. If you compare it to the left versus the right, there's a gap right there.
And from what you observed from that video, does that appear to be consistent with what you observed on January 29th at the Kent Police Department, February 1st, and in the item of evidence that was just marked?
Yes.
Thank you. Ms. Gilman, you can take that down. Mr. Officer, we can have the lights back on. Thank you. Now, sir, you proceeded to 1 Meadows Ave for the first time on February 3rd, is that correct?
Correct.
And Trooper Brent from Crime Scene was with you and took some photographs, is that correct?
Yes.
May I approach?
Yes.
And Trooper, I'm showing you a set of 10 photographs. Ask you to view those, look up when you're finished.
We want to get to the text messages, though. All this is cool, but let me see if I can find him reading the text messages.
Date and time, correct?
Yes.
Okay. What is the first message sent date?
It's
here we go.
10/18 of 2021
Wait,
at
who's-
8:48 a.m. The last message sent is 8/31, 2022 at 11:19 p.m.
Whose text messages?
Is
are
there
these?
also within that conversation details an indication as far as number of messages over that time frame within this community, correct?
That's correct.
Listed within,
6 p.m.
and if anything, what is that in reference to?
He just recently moved to Tennessee, and he was common to be carry around there.
And the next message, sir, from that same page, 2527.
The next one is it's bold.
And is there a name associated with that number that's in these?
No,
Do you know who that person is?
I don't.
And the next message, sir, from 10:52 p.m.
Chip, name of that BPD cop.
And Chip, who is that referring to, sir?
That is one of my nicknames I've had since maybe high school.
Oh, okay. Here we go. We get into the text. Proctor reading the text messages. Oh boy, here we go. This is gonna be good.
Just be mindful of the step up and just remember what's going on.
I just want to see his face when he reads this.
So, jurors, before we begin, Mr. Lally, as you approach the podium there, when I tell you that I strike something from the record, I know I've told you before, that means you're not to consider it, okay? Go ahead, Mr. Lally.
Thank you. Good afternoon, sir.
Good afternoon, sir.
So, with reference to,
Thank you, Misty.
I believe before we broke, we were talking a bit about Julie Albert and Christopher Albert, correct?
Yes.
And how would you describe your relationship, if any, between Julie Albert and Christopher Albert prior to January 29, 2022?
Loose acquaintances.
People that you knew through your sister, is that correct?
Correct.
Now, with reference to the occasions that you had said where you may have been at the same place at the same time at a family function or something like that, over what period of time are we talking about, and about how many different instances of that occurred over those years?
Like I mentioned, they had never been at my house. It was either at my sister's home or at my parents' house.
Yep, we're getting into the text.
Over the course of maybe 10 years, I might have been at the same function half a dozen times.
And at those times that you were at the same function a half a dozen times or so, how much interaction would you have with either Christopher Albert or Julie Albert or even Colin Albert at those functions?
Just casual conversation, be cordial, and just typical conversations, you know, hi, how's it going, things of that nature.
Now, with reference to these experiences or relationships or lack thereof that you had with Christopher and Julie Albert, what, if any, conversations did you have with your supervisors as far as superior officers within your unit in regard to those?
I explained the connection with my sister to the Albert family.
And who did you explain that to, sir?
That would be Sergeant Mechanic, Lieutenant Fanning, and Detective Lieutenant Pelly.
All right, Trooper, I'm going to ask you to keep your voice up, maybe approach the microphone a little closer.
And just with respect to those disclosures, what specifically did you tell either Sergeant Mechanic or Lieutenant Fanning or Lieutenant Pelly?
Basically, that the Alberts are my sister's friends. That I've been at some functions with them, and the only kind of connection with the Albert family is through my sister.
And just when you say the Alberts, as far as who
Who's his sister?
specifically within the Alberts are you talking about that had a friendship with your sister?
Julie, Chris, and their son Colin.
Now, with regard to the investigation that you were conducting and the interviews that you conducted, what, if any, impact did that those relationships have with regard to your interviews of them specifically or the investigation in total?
Zero. Absolutely zero impact on this investigation.
Your Honor, may I approach?
Yes.
You're good, Misty. Amy said, yeah. I knew Amy was going to say something.
Sir, I'm showing you a document. Do you recognize that?
Yes.
And what do you recognize it to be?
It's a text message thread
Uh-oh.
labeled Proctor Friends.
Now, over the course of your investigation, over the course of this
Here we
case, you're
go.
aware that there were iCloud data that was obtained from your personal cell phone
Yes.
and different text strings from that iCloud data from your personal cell phone, correct?
Correct.
And with respect to what has just been placed before you, is that an excerpt or piece from those particular messages?
It is.
And from the front page of that, can you tell the jury who are sort of the participants in this particular text communication?
There's several numbers that aren't identified. The three that are under kind of nicknames me and my buddies have for each other.
All right, guys, we have some breaking news. We're back in the courtroom. The jurors have a question. So let's go ahead and give Proctor a break here before he gets utterly exposed for being a POS. Let's see what Judge Bev has to say to the jurors. It's going to be interesting.
Please be seated. Court is in session.
Excuse me. I was just informed that somebody keeps just.
So, counsel, why don't you come on up?
Okay, so we're going straight to a sidebar. What do the jurors want to know? Amy's asking. Can you guys imagine? Can you guys imagine? I don't even want to speak it. Where's Aiden at? Aiden's not in there today. That's odd. Let me see if I can skip ahead. We are on a slight delay. Now we're caught up live. What do y'all think it could possibly be? Sidebar, says Dominique Carter. Yeah, Nosy Rosie asked the same thing I did. I don't know. Aiden's not there. I wonder what happened. Maybe he got caught up with something else. Let me see what y'all are saying. The foreman is a chill black dude with dreads. Is that what they said? Really? Did Aiden say that? That's funny. I thought they removed all. I thought there weren't any more black jurors, though. I thought they got rid of them. So we're going to have to wait and see what happened. He wears a gold chain. Really? We're still waiting to find out. TV said they're in the courthouse. That's really what he said. He said he was instructable and chill and took no notes. Interesting. Shout out to all the cats out there. Poor Misty. It's her first day. Let's give her a break. Thank you to Amy for the super chat and the super sticker. There's a couple super chats I didn't read too while we're waiting here. My guy Vintage CB up in here with the 10 bombs said appreciate all you do, ClassE. Appreciate the support, man. Thank you. Amy had the cake. She's ready for cake, y'all. And she dropped the cat super sticker too. And Vintage, my guy, became a new member. Welcome to the member side. Make sure you check out everything that's going on over on the members only side. Let's see what's happening. Here we go. Karen's smiling, so it might be good news.
Bob, I can't do this. I can't do this.
What's happening? What is happening? We're waiting. Oh, Aiden seen Drain yesterday walking out of the courtroom. AJ. Oh, you said AJ. Amy said AJ is stressed. Yeah, I can't imagine. Let me go. I'm going to find that video you posted, Amy. Let me see. Let me see if I can find that video yesterday. Because Amy posted the video of them walking out of court yesterday. Let me see here. I'm sure AJ's feeling it. Karen was just smiling a second ago, so this could be good. It could be bad.
Here's number 3.
Why, I wish Karen would have had a Twitter account. I know I said she needs to stop talking, but I wish we could have gotten some updates from her. Let's see. There we go. Y'all are saying Karen could practically be an attorney at this point. She's learned so much. Yeah. Big difference I'm seeing between the first trial and this trial. Here we go. While we're waiting on them to get their stuff together, Amy posted this over on X. Let me see if I can play it for y'all. Oh, hold on. I've got X muted.
I'm done. Karen, are you hopeful the jury will reach a verdict?
Stay here until you're ready to be done, and then we're going to cut it off.
I'm done.
You're done?
Yeah.
Okay, no comments right now, guys. And do me a favor. The cameras weigh a shit ton. Give me some room. She needs room, we need room. Okay, let us walk.
And we need room on the sides as well.
Yep, just let us walk. You'll get all the pictures you need.
Hang it in there, Karen.
Yeah.
Do you have any comment you want to make?
Seemed a little testy.
Any message to the supporters?
There's going to be no comments.
A little faster, guys.
Don't trip. Thank you. Thank you.
You got an attorney behind her forcing a smile. They're stressing.
Here we go, guys. Keep it going.
All right, let's see if we have any updates here. They're talking.
Questions from the jury. The first one is.
Hold on a second.
So,
here we go.
Counsel, what I'd like to do is I'm just going to read the questions to you now. So please take your seats. So I'm going to read the questions. So please, counsel, what I'd like to do.
Let me rewind this real quick. All right, here we go. So it looks like the jury has some questions. Let's see what they're asking.
Counsel, what I'd like to do is I'm just going to read the questions to you now. So please take your seats. So I'm going to read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
Thank you.
So, all right. So I received 3 questions from the jury. The first one is, they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5.
Called it.
OUI at 12:45 or OUI at 5 a.m.?
Y'all called it.
The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2 number 5, convict the
great.
overall charge?
This is beautiful.
So I will
for
give
Karen
you some
Reed.
time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence, and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Reed. So think about that when you when
We'll review the verdict
I come
sheet.
back out.
The verdict slip
But I think
shortly.
it's appropriate to give a humane practice instruction. And also tell me what you think about
This is great
what to
for
say
Karen
about the
Reed.
weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know
This is
yesterday I
great.
said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not
We'll go through the
specifically put in here,
subcharges
but I
shortly,
think
guys.
it takes it step by step, an analysis to do it. So how much time does the defense want to be able to respond to me?
30
Perhaps
minutes.
15 minutes.
Okay.
Oh, he said
And the
15.
Commonwealth?
There you go.
That will suffice.
Okay, so it's 7 past. Why don't I come out at 25 after? Give you 20 minutes.
Thank you.
Oh, this is beautiful. We called it, guys. We reviewed the verdict slip yesterday, and not only did we know that section 2 was going to be confusing, we're going to review it here in a second, but we had a feeling, and I said I personally, as a juror, would probably charge her with section 5. And if y'all want to see this again, we can go over it. All right, we've got simple part here. Now let me zoom this in so I can make sure y'all can see it. Pretty straightforward on offense 1 and 3. Let me move this so y'all can see. All right. So here's the verdict slip. Murder in the second degree, pretty straightforward. Then we go down to section 2, which is manslaughter. And they put all this here. They've got not guilty as number 1 on the offense charge or any lesser included offense. They're not worried about number 2, right? They're not worried about number 3, number 4. They're concerned with number 5, which is what we talked about. Operating under the influence of liquor. All right. Operating a motor vehicle under the influence of liquor, operating a motor vehicle with a blood alcohol level of 0.08 or greater. Now, they did ask about, I think they used number 2 as an example, but that may be because it was just the first one that they saw. Manslaughter while operating a motor vehicle under the influence of liquor, manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. So I want y'all to let me know what you think. I feel like this is a good sign for Karen Reed because with the alcohol section, the alcohol part of this, it was confusing. And it seems like the jury's struggling with figuring out, especially number 5, how to charge for this without saying she's guilty on everything else. So maybe they'll fix that. Maybe they won't. Let me know what y'all think about this. Crazy. I think this is a great sign. What do y'all think? So many guilty options. Yeah. And I want to let me run this back real quick because they said something. They used section number 2 as an example. And then we got the third section, which was our offense 3, leaving the scene of an accident resulting in death.
Today I said they have to be red hands. That's instruction, and also tell me what you think about what to say about the weight.
Yeah, the verdict slip.
The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2, number 5,
oh, so no, they're still asking about number 5. Guys, she's about to get acquitted of everything except driving drunk, which was stupid on her part. I think this is great news for her. This is great news. Jury, don't deliberate. Listen, just take my advice on this. Guilty on number 5. Guilty on number 5. I mean, Karen, you should know better. You grown. Stop driving around after you drink. Everybody. Stop drinking in general. Can I say that?
Convict the overall.
Some of y'all might have missed it, so I'll rewind this. The jury has some questions, so those of you who are just joining can hear what went down.
Counsel, what I'd like to do is I'm just going to read the questions to you now, so please take your seats. So I'm going to read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
Thank you.
So
I think this is a great sign for her.
I received 3 questions from the jury.
Stop drinking in general? Nope.
The first one is...
Okay. No judgment here.
They appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5. OUI at 12:45 or OUI at 5 a.m. The second are video clips of Karen's interviews evidence. How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now.
Yeah, stop drinking and driving, period.
Pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence, and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Reed. So think about that when you when I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as
Most
I did
extensive
before,
DUI
that
in
they
history.
start
Yeah.
at the top and work their way down. That's the only thing I did not specifically put in here, but I think it takes it step by step, an analysis to do it. So how much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay. And the Commonwealth?
That will suffice.
Okay, so it's 7 past. Why don't I come out at 25 after, give you 20 minutes?
Thank you, Your Honor.
Okay, there it is. Hear ye, hear ye. Let's get back to Michael Proctor. But yeah, I think this is great news for her. What do y'all think? Let me see. What are y'all saying? Amy, I want to hear what you think too. Let me know. Let me know in the comments. Being on trial for 3 years should be considered time served for the friggin' OUI. I agree with that. I think that would be fair. Let this be a lesson to you all. Stop driving drunk. If you're going to go out and drink, do the right thing. Be responsible. Driving after you consume alcohol is in no way responsible, period. Nobody should drink and drive, including cops going to move police vehicles at a police station on the night of a blizzard. I agree. What's crazy to me is the police officer not only let her drive drunk, speaking about John O'Keefe, rest in peace, but got in the car with her. Yes. And 4 other law enforcement people who were with her let her drive too. Dang. Dang. Well, at least she didn't hit him with the car while drunk. I agree. And yes, drinking and driving is not a good thing. I've lost too many people in high school. Yeah, hopefully today is a celebration martini. You guys, man. Go get some ice cream or something. At least you can walk that off. My guess is that at least one juror is looking at the alcohol charges, not necessarily all of them. I think it's just number 5, like they asked about. I think Karen Reed's about to walk up out of there guilty of OUI, and that's it. They're looking at the videos. They should only be able to consider them on the full context, not snippets. It's the price you pay for opening your mouth. I mean, maybe. I don't think they should sit there and watch the whole documentary, but I don't know if the whole thing was let in. So that's going to be an issue. Just charge them all at this point. I agree. They should all be charged. I think police officers should be standing outside of bars. One at every bar. Think of how many lives could be saved if that happened. Think of how many lives could. Anyway, had to check out, press the like button. Thank you for being here. Appreciate you. I would prefer them to take their time to understand everything to the best of their abilities before making such a massive decision. Yes, I agree, Amy. I had the joke I was going to make, but I'm going to keep it to myself. They have at least one person worried about the OUI, maybe only one person. 30 minutes to verdict. You think, oh, that's a good question. So it looks like 73% of you say, yes, we're going to have a verdict today. 27% of you say no. Once these questions are answered, let me know in the chat. And I'm glad Libby started this. How long do you think it's going to take them to get to a verdict after they answer these questions? Yes, it's poison. That dumbs us down. Alcohol. I agree. This is a woman's life at stake. I hope that's all she gets. I think it will be. Again, y'all, that was my prediction at the beginning, and it's looking like we might be right again. That's exactly what I would have done as a juror. Me too. Oh, give us the joke. No. Well, then are they going to investigate who really killed John O'Keefe? Are you asking me if the Commonwealth is going to admit they got it wrong? Are you telling me that they're going to say Gallagher, Yuri, Proctor, those three guys alone failed to do their job? Come on. Let's be serious here. You want me to think the Commonwealth is going to admit, maybe we should have looked inside the house. No, they're going to throw up their hands and say, hey, Peggy, John Sr., we tried. The jury just didn't see it our way. You know, maybe you guys will have to do what you got to do to cope with what happened, but she got away with it. You know, we did our best. That's exactly what's going to happen. How long before we need to wait before we shout free Karen Reed? Where the feds at? You mean they would you mean they would bother to tell us the truth? No. No one's going to hold out on an OUI. Pee Wee spent a cool meal for a DUI. Oh, dang. I think we will never know because the investigation was so bad. How could they solve it now? The house has been completely, the evidence is gone. Chloe's missing. The garage, the basement doesn't even exist anymore, according to Amy. What? They got rid of the garage, which is super random. What did Amy say here? Oh, okay. I got to skip over a couple of these messages. Larry Foreman says the DUI guys says, I want to remind everyone that it takes a moment for the jury to sift through and understand fully the jury instructions that they are tasked with, plus going through all the evidence between 12 people. It takes time, especially as I mentioned before, you have some jurors, at least one juror that's going to be difficult. I know that over the last couple of years, we have all become experts on the Karen Reed case. However, this jury does not have that luxury as they have been in a vacuum for the past 11 weeks. Give them time. They know what they are doing. I have faith. And here's Amy's analysis. She says, the defense proved that every indictment and charge is loaded with reasonable doubt. And in my opinion, the Commonwealth did too. The Commonwealth did as well. Amy says 5 experts, including the MA state examiner / forensic pathologist, said the injuries to John O'Keefe were inconsistent to a vehicle striking him. And yet the jury is still out. Even the prosecution's experts, Aperture, can't say with 100% certainty as to exactly what happened to him. They can only speculate with blue paint. If you all were listening, even Brennan in his closing said that Reed didn't intend to hit John O'Keefe. Even the DUI charge is horse shit. My bet in this is headed for another mistrial, or they will get her on the number 5 OUI. Amy, do not say another mistrial. I don't know how much more of this I can take. Listen, I'm gonna be real with y'all. If there's a mistrial and they have to do this again, I'm not covering this again. We're not gonna watch this trial again if there's a mistrial. We'll wait and we'll do a verdict watch, but we're not gonna sit through this again. We've seen everything we need to see. There can't be a mistrial here. They can't retry this. I'm not doing it. Thank you to Amy for her Amy analysis. Yeah. There can't be a mistrial. There cannot. They can't. I'm not. No. Nope. I've seen enough. We're already watching this clown up here talk about text messages he sent to his super trial. His His supervisor. No. Like I said, mistrial with prejudice. Mistrial with prejudice? I mean, I guess double jeopardy could come into play. I don't know. Again, I'm not an attorney, so I don't want to get into all that. You sound pre-traumatized. I am, man. I can't do I am vicariously traumatized. This is crazy. Cassie, how long have you been doing YouTube lives like this? As long as I can remember. Yeah, once is enough for me. I can't believe this guy was taken seriously. I don't think my anxiety can handle another trip. I hear the jury have a question. Is that correct? Yes, Sean, you might have to rewind. I saw a video of the retired sergeant of the Canton Police Force interviews several of the witnesses and have admitted to a fight and accidental death that night. I'm sure the feds will be all over that. I wouldn't be sure of anything when it comes to the Boston PD. Not guilty on all charges? Danny, no. Has anyone seen my question above? I didn't see it. How many times can they legally retry? As many times as they want to. I will not watch the circus again. Brian Albert, sir, grew up in that home, and raised his family in that home. The boom sold. That's so suspicious to me. And they got rid of the garage. Or maybe they will be not guilty, says Amy. She's not guilty, but they're going to find her guilty. On which count? I think number 5. Count 2, 5. Yeah, she should be found guilty on, in my opinion. The rest of it, I don't know. All right, let's get back to Proctor. Amy says, key thing that stood out for me, the jurors wanted to know how long would she get on certain charges. Tells me they don't want her to go to get prison time. That's some good insight there too. Do y'all want to rewind it back one more time and hear what Judge Bev said? Let me see. Let's play it one more time. Camera's shaking a little bit. And it's been 20 minutes already, so we should be back here soon. I'm going to rewind it one more time for y'all. And see if I can get this video figured out.
Counsel, what I'd like to do is I'm just going to read the questions to you now. So please take your seats. So I'm going to read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
I think this is good.
All right. So I received 3 questions from the jury. The first one is, they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5. OUI at 12:45 or OUI at 5 a.m. The second are video clips of.
And this is important too, because we talked about this.
What is the time frame for the OUI charge? Offense 002, Section 5. OUI at 12:45 or OUI at 5 a.m.
And this is what y'all talked about with Karen Reed going home and allegedly getting drinks and having drinks, right? Because she was upset about John, didn't know what she was doing. So There's that part of it. It sounds like they don't even want to charge her with that, which is insane. Because again, this jury is more reasonable than I am. This jury is thinking like a lot of you guys were thinking, well, it's the time frame. When did they take her BAC? Did she go home and have drinks and then went to the hospital? Like, they want to be fair. Me, I'm like, no. You had already been drinking and driving the whole day. You getting the OUI. So I'm glad the jury's as fair as you guys are, because I'm a savage out here. 40 years old driving.
The second are video
drinking.
clips of Karen's interviews evidence. How can we consider them? And the interviews evidence. The second are video clips of Karen's interviews evidence. How can we consider them?
Okay, this could go into, again, her admitting that she was drinking. She was drunk. She had a lot of drinks.
And the third, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you.
Because it sounds like they're saying, hey, she's not guilty of manslaughter, but this drinking thing, we got some questions. But we're not going to say she's guilty of manslaughter, or we're not going to say she's guilty of, as y'all said, OUI, if that means she's going to be guilty of manslaughter. Fix it, Judge. It's a smart jury.
You as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence, and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Reed. So think about that when you
think about it, Judge Bev.
I come back out. But I think it's appropriate to give a humane practice instruction. And also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not specifically put in here, but I think it takes it step by step, an analysis to do it. So how much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay. And the Commonwealth?
That will suffice.
Okay. So it's 7 past. Why don't I come out at 25 after, give you 20 minutes?
Thank you, Your Honor.
All right.
All right, we should be good to go. Let me see. And they should be back by now. So let's see if we have a decision from the attorneys. Yeah, here we go. We're back at it, guys.
Please be seated. Court is in session.
All right, so I will hear you on the first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from you're standing up, so I'll hear from you first.
Okay. On question number one, what is the time frame for the OUI charge?
Get in the car,
Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m. Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
Good morning, Nana.
Mr. Brennan, or whomever from the Commonwealth?
My suggestion would be 12:45.
And why is that?
Of course, because it fits my narrative, Your Honor.
Focused at that time. I don't think there's anything specific in the indictment or regarding the time.
Do we have the indictments?
No.
If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
Judge Bev said, "Wrap it up."
Court, on principle, I just don't have the indictment memorized, so I don't remember. If we can pull that up.
There's no time? I don't expect that there's any time to be.
All right, so I'll say you have the evidence, and remember, you are the fact finders, or something to that effect. All right.
Whatever that means.
Are the video clips of Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them. And then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you. Otherwise, it's fine.
Hot mics, hot mics. Oh, we got some.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
I bet you
The first
do.
part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been introduced substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited.
I think that's
Just
fair.
like
I
a
agree.
photograph, it's no different than a physical piece of evidence.
Y'all aren't going to like it, but I agree with that
Yes, you should
from a
weigh the
legal
defendant's
standpoint.
statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. It suggests that there's some deterioration or further analysis that is different. Those instructions
I agree.
were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence, and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
Yeah, so, y'all can't hear Hank because he's mumbling. Yeah, so basically Hank is saying evidence is evidence, as RC said. Evidence is evidence. If you let the clips in, you need to consider the clips as evidence. They don't have a lesser weight than the tail light in the evidence bag or the red Solo cups. It is evidence. It was allowed in. It shouldn't be the qualifier of, you can consider that as evidence, if at all, makes it seem like maybe there's something there and it's not as good as an evidence as something else. So I 1000% agree with Hank on this, which is weird to say. Ugh, I gotta go take a shower. Ugh. But he's right.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws, in keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law.
Yep. Karen should have kept their mouth shut.
The Commonwealth's suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think the appropriate comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
I disagree with AJ on that because they're supposed to consider the evidence and the clips are evidence. So don't say, hey, take our evidence. But when it comes to those clips that our defendant decided to, or we encouraged our defendant to create by doing these interviews, don't worry about that so much. No. You don't get to have it both ways. It's either all or some. Come on. Shout out to AJ, but no. Thank you, Vintage Galleria. Cynthia Hart says give them the whole thing. Pretend you never saw those. It's not saw, it's SAR. It's his job to try, I agree, but he's wrong. What you gonna do, Bev? I know what she's gonna do. She agrees with the defense on the first question. She's gonna agree with Hank on the second. Oh, I could do it this way. No, what he is saying is that MA law says the jury can give whatever weight they want if to any of the evidence provided. Yes, but they didn't have I get that that's the law, but they didn't have an instruction specifically when it comes to those clips. So that reminder focused on the clips specifically would seem somewhat biased, and I don't think it would be fair and right. Bev's not going to do it either way, so I don't think our opinions matter at this point. I think once they get their questions answered, we'll have a verdict very shortly. As long as they're quick, as long as Judge Bev is clear with the answers and isn't confusing them even more. Because we all saw this verdict slip. Like, gee, what is this? Should have been not guilty, guilty on offenses charged. Not guilty, guilty of lesser included. Not guilty, guilty of lesser included. Not guilty, guilty of lesser included. It shouldn't have been not guilty, 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 guilty. Come on. That seems intentional.
All right. So what I'm going to say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, then I'll go and I'll read the electronic communications and the humane practice. That covers it.
I don't have a principled objection to it if the court adds the word "if any."
I understand.
Because I don't want them to think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay.
Okay, so then say that. Say, because you can't just say one statement. You say you can give it weight or you don't have to give it weight. Not throwing if any in there makes it seem like you're saying, you're implying a lot. So I get what AJ's saying. I don't agree with this wording, but I get what he's saying.
So your objection's noted. Now let's get to the third one. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
Hank shouldn't have anything to say on this. He needs
But I
to sit this one
appreciate
out.
the effort that the court went to amend the verdict slip as it relates to count 2, and I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously. And
the answer is no.
Perhaps we could formulate an answer that says something along the lines of no. New verdict slips have been provided that will make it more clear, or something of that nature, as well as a decision of guilty on the OUI charge 002 number 5 is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law.
That's even more confusing, though. I don't know.
And then there are suggestions that we have regarding the edits that the court has made to the verdict slip. And I'm happy to go over those with you.
Okay, go ahead.
With regard to going from the top to the bottom, just under number 1, number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the consistent language that it's added throughout the verdict slip. If you, quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right, I think I'm going to leave it because it appears only under the guilty.
It appears only on?
Under the guilty. So go ahead. I'll hear you further.
Going further, going under number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent, if you find the defendant guilty of the lesser offense of involuntary manslaughter, we would simply add that clause.
So we'd have to add it in all of them.
Correct.
Which makes sense. I think
Correct.
we had it in the first one.
Right.
Okay.
And then moving to page 2, at the top of the page under sub 4, again.
Hold on one second.
Of course.
I'm talking about right here. Motor vehicle homicide, felony OUI, liquor, and negligence.
Okay.
I don't think this jury thinks
We
that
had the
she
same
did it.
suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following. And there's a typo. It says the parenthetical
We
says
fixed it.
check one of. Okay.
Yes, so we changed of to or.
So my only suggestion to that would be to, again, add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense of motor vehicle homicide.
Okay.
Moving down under sub 5, the
We still
OUI.
need to say stop and sign the verdict slip.
Right. After the word
She's
stop,
innocent
stop
based
and
off these
sign the verdict
questions?
slip.
Yep.
Yeah.
And then under sub 5, again, the same thing. We just suggested that for consistency that it say, if guilty, check one of the following of the both. And the final edit would be in the final parenthetical, the last sentence. If you find, I think her should be changed to the defendant. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And those are the edits that we have suggested for the verdict
All
slip.
right. Mr. Brennan?
I don't have any disagreement with the edits.
Okay.
Good.
The
You shouldn't.
idea of instructing them on the nuance of selecting one guilty or not guilty, I don't think needs to be explained. I think with the edits, this proposed instruction explains it. Yes.
All right. Would I?
I don't have any issue with if you state, if you decide on a lesser included offense, it does not include the earlier offense.
Hank, just stop. Come on, man.
I don't think that's necessary, but that is something I wouldn't have an objection to, but I think the form that you filled it
Just
out.
let it go.
is going to be sufficient for them to follow.
Jeez.
What do you think about the defendant's position that if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have found her not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense, it would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain, if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something.
I prefer that.
I think I'll walk them through it like we do in civil cases.
I don't have any objection to that. The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should re-emphasize that, and we're not asking for it.
All right, so you're waiving it?
We're waiving it.
Okay.
Yes,
All
thank
right,
you.
I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can, and we'll make copies. So we'll bring the jurors in. Let them know that we'll be bringing them in shortly, Tony. All right, thank you.
All right.
There we go. So I think we should be able to skip ahead because she said 5 minutes. We should be able to skip ahead to when the jury comes in. So let's see. How are y'all holding up in there, though? I know we have a lot of conversation about this. Can someone please tell me what a humane instruction is? Where are our attorneys at? That's what it should have been all along. Why is a judge not understanding how to write a jury verdict form in the first place? If I were Hank, I'd call the Corleone family and see if there's anything they need. Oh man, that's funny. That is funny. Let me see here. What else are y'all saying? Oh no, did I mess this up? There's no distinction between a state and commonwealth outside of historical designation. Yep. Well, we know that's not happening. No, I think Bev, it seems like she's being fair. Y'all are saying free Karen Reed, Commonwealth does not really mean anything. Yeah. But they tend to have similar legal systems and processes, and they tend to avoid breaking tradition over updating to new and better procedures. All right, let's see if we got them in here. Not yet. We're still on the fan. So let's go back to Michael Proctor for a second. And even Bev wants Hank to yeah, shut up. I agree. Let me read a couple of these super chats. We had Vintage CB became a new member. I think I mentioned that last time. Thank you, my friend. Welcome to the member side. And then Curious Coco New York with the 5 bomb says, in my opinion, since they're not taking or not asking evidentiary questions or for transcripts, they're ready for a verdict and the slip is confusing AF. Let's go free Karen Reed. I think that's a great assessment, Curious Coco. They're ready to fill this thing out. They've already made their decisions on the other ones. It's just that second section y'all saw was absolute trash. And this says to me, they're like, no, she didn't murder him. No, she didn't leave the scene of an accident resulting in death. But was she drinking is the question, because that's what section 2, or offense 2, is about. Was she drinking? And they're trying to figure out if she was drinking. And I think it's pretty clear that she was, in my opinion. But again, I'm y'all are more gracious than me. Amy says, when the judge says humane instructions, they're typically referring to specific legal guidelines or procedures designated to ensure that individuals are treated with compassion, dignity, and respect, especially in vulnerable situations. Cynthia Hart says, ClassE, I love your optimism. I wouldn't say it's optimistic. I think just based on what we saw from the trial, again, guys, the jury is full of people just like you and me. It's not full of attorneys. It's not full of legal analysts. It's full of regular, everyday Commonwealth folk. So we can pretty much get an idea of how they feel and what they're thinking based on the questions they asked, based on how both cases were presented, based on what we saw, and based on the conversations we're having here, which is why I love this show. And I think it's an amazing place because we get a lot of feedback. We get into the mindset of the conversations that are being had most likely behind closed doors. The reason that they focused on this section, again, is because we had already been talking about it and the jury is full of people just like us. So I wouldn't say it's optimism because, I mean, if Karen Reed were found guilty on everything, let's be real, I'm gonna sleep just fine tonight. And that's probably an insensitive thing to say, but I say that to bring home the point that, you know, we're not involved in this case. So one way or the other, the system is what the system is. I'm just looking at this as someone who could be on the jury, as someone who's seen all the evidence that's presented and saying, I cannot see how anyone would think she's guilty after the case that's been presented. And that's it. So I wouldn't say it's optimism. I'm just saying I just see it for what it is. Amy also says, in jurisdictions that follow the humane practice rule, judges may or must instruct the jury that if they find a confession or an admission was not voluntary, they should disregard it. Interesting. All the defendants we follow are not guilty. Melody C says, no, that's not true. Rocky wasn't guilty. Young Thug wasn't guilty. Shout out to my guy Shannon, but I said, man, he's gonna get called on. I knew they were gonna get him for that gun. Yak Gotti, not guilty. We had Jason Levesque. We went through that. The snowplow shooting. I knew he was gonna be found guilty. It's just, you just look at it based on the evidence and what's presented, and then the conversations that we have here. So Amy says, in essence, humane instructions from the judge reflect the legal system's commitment to protecting the rights and well-being of individuals and animals, even when enforcing laws or dealing with legal proceedings. John says, if she's guilty of the OUI, then everyone from that night should be found guilty also. Well, to find someone guilty, you have to indict them. And that's not going to happen. But I agree. The judge knows it's going to be not guilty on murder, but wants to get at least the win on the OUI and sentence her to 2.5 years in prison. You think I don't know if Bev would do that. But it's possible. I don't think she would do that. After all of this, I don't see her doing the 2.5 years. That would be a little much. Anyway, let's get back to Proctor. He's finally going to read these
generally
text
speaking,
messages.
just as far as the participants in this text communication, who are these people to you, and how do you know them? How long have you known them? Who are they?
The members on this text thread are close friends from junior high, first grade even.
So people you've known for years, is that correct?
Correct.
And do each of them live, or do any of them live within the general area at this time?
Some of them do, yes.
And so when some of them do, some of them do not, is that correct?
Correct.
And the ones that do not, how far away do they live?
As far away as Tennessee.
Now, with reference to this, there's an indication as far as the first message sent or last message sent from this particular text chain, correct?
I'm sorry, repeat the question, please.
Sure. Sort of towards the middle of the first page. Help direct your attention to that area. Is there any indication as far as the first message sent and the last message sent with respect to this text chain?
On the first page, yes.
And what is indicated as far as the first message and the last message?
The first message is, I need to brandish a gun more often. The last is, Chip, name of that BPD cop.
No, I'm sorry, sir. If I could direct your attention to the first page in this packet, page 2527, you see conversation details. I'm sorry, may I approach?
Yes.
Sir, if I could direct your attention to the right.
Okay.
Do you see what I was talking about now?
I do, sir.
And from that area labeled conversation details, there's a first message sent, date, and time, and a last message sent, date, and time, correct?
Let me
Yes.
see
Okay. What is the first message sent, date, and time?
It's 10/18 of 2021 at 8:48 a.m. The last message sent is 8/31/2022 at 11:19 p.m.
And is there also
think
within that
she's gonna max
conversation
her out?
details an
Not
indication
yet,
as far as
Misty.
the number of messages over that time frame within this communication?
There is.
And what does it list for number of messages?
It's 38,707.
Jeez.
And fair to say the packet that you have before you does not contain all 38,707 messages, correct?
That's correct.
The first message that you had, I believe, alluded to in reference to the first one listed within this communication, what date and time is that?
That was January 29th, 2022 at 10:36 p.m.
And who is that message from?
My friend who lives in Tennessee.
And what, if anything, did he send to the group?
I need to brandish a gun more often.
And if you know, what is that in reference to?
He just recently moved to Tennessee, and he was kind of, I think, making a joke as kind of the lifestyle down there where guns are more prominent or more common to be carried around there. So I interpreted that as a joke in that nature.
And the next message, sir, from that same page, 2527.
The next one is, it's bold.
And is there a name associated with that number that's in these?
No,
Do you know who that person is?
I don't.
And the next message, sir, from 10:52 p.m.
Chip, name of that BPD cop.
And Chip, who is that referring to, sir?
That is one of my nicknames I've had since maybe high school.
So a nickname that would be familiar amongst these group of friends in particular?
Yes.
And this time period when these text messages begin, sometime after 10:30 or 10:50 p.m. on January 29th, where are you and what are you doing in reference around that time period?
At this point in time, on the 29th, I'm home.
And that last text message, do you respond to that at approximately 10:53 p.m.?
Yes.
I agree.
And what was your response?
John O'Keefe.
And the next message down from there, also at 10:53 p.m.?
Yes. The custody of the sister's kids.
That's your response. There's another response above that, is that correct?
Yes.
And what does that say?
How old?
And you respond as far as he took custody of his sister's kids, correct?
Correct.
Skipping down a couple, do you see an entry at 10:53:49 p.m.?
Yes.
And that's from a 617 number, is that correct?
Correct.
And what is the response there?
Oh man, that's rough.
And following that, do you respond to the earlier query as far as age?
I do.
And what did you say?
Mid-40s.
Now, the next message below that, as far as indication of mid-40s, what is that?
His age.
No, I understand that. I'm sorry. The next message underneath that, sir.
I'm sorry. It's a Facebook link.
And do you recall what that Facebook link is to?
It's to John O'Keefe.
And is that something you sent or one of your friends sent?
One of my friends sent.
And the next message below, turning to now page 2529 at the top there, what is the next message that's sent?
What's that? Don't have the book anymore.
And as far as the book, what did you understand that to mean?
Make me approach.
Sure.
They had a sidebar. I want to get back to these text messages. Hold on. It's so interesting to see how Karen was not approaching with them.
Doing all right?
So do you have that copy for me?
All right.
They must have taken a break. Skip ahead, getting back in here. And shout out to Brandy in the building with the 5 bond says, if I was an MA taxpayer, I'd be super salty that the Commonwealth spent over $1 million to essentially prosecute a DUI. Man. That's a great point. That is a great point. And thank you for the super chat, Brandy. Think about Fulton County. Here in Fulton County, we paid all this money for 0 murder charges during that YSL RICO. 0. Not one person was convicted of murder. So we have 2 unsolved murders throughout this entire however long it took trial. Disgusting. Amy said, y'all heard AJ say I can't do this again hot mic earlier when the judges was talking about questions. Uh-oh. Uh-oh, that's not good. That's not good. All right, let's keep going. Said I can't do this again. I don't blame you, man. I'm not doing it. AJ, you're on your own.
Proceed, John.
Yes.
Trooper, if I could direct you back to page 2529 within that packet before you. And below that text stating what's that, I don't have the book anymore. You respond, is that correct?
Yes.
And what is it that you say there?
This one is a nightmare. Forget about the kids. That's awful.
And sir, if I could direct your attention again within that same packet to 2532.
I don't want to think about it, John. And they're back. All right, hold on. Give me a second. Give me a second. All right, let me see if they're back. Yep, here we go. They've got the updated forms. This is wild. What a wild trial this has been.
All right.
Be seated. Court is in session.
All right, so we can bring the jurors over. Tori, do you have those? So Tony will take those. All right, so I'll take. Thank you. Tori, how many did you make?
Can you send us over a copy too? I want to see what this looks like. Can we get a copy? They're reviewing it now.
All rise for the court, please. Jurors entering.
Here we go.
Court is back in session. You may be seated.
She's not smiling now.
All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right? That's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay? All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is, 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor, and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip.
Oh,
that
so you
means
put that in
on
there.
each one,
Okay.
when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first, under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor, and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor, and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors are set up,
Sure, why don't you come on over?
I think she did a great job with those. I think this is a good update. Should have been done the first time. But boy, it's going to be interesting to see what goes on here when the verdict comes out today. And what are y'all saying? It looks like, again, 73% of you believe that there will be a verdict today. I'll have to wait and see. We'll have to wait and see. Man, this is wild.
I heard myself say this, and I'm glad counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony, OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said, then find, I don't know what I said. I heard myself read the guilty of the lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay? Thank you very much. We're going to release you.
All right, the court, please. Here's Lovey.
They're about to stop for lunch, too. Shout out to my dog, Stephen G. in here from Down Under. He says, ClassE, she's confusing the jury, I think. He's confused on if the jury's confused. Boy, that's tough. All right. Shout out to Stephen. I think it makes a lot more sense. I want to see the form, though. And then Raunchy Dog in here gifting the 5 memberships. If you got a membership from Raunchy Dog, say thank you. All right. Showing so much love in here. Thank you. Thank you.
Are you satisfied, Ms. Giannetti?
Yes.
Okay. I'm going to ask everybody to stay a few minutes. I'll be back out in about 5 minutes.
All right.
Questions and thoughts. And
interesting. So we've got some more stuff going on here. Let's see what Bev has to say. Lunchtime. Wow. That means they can stop at the General 2 and sign the verdict not guilty and not worry about the OUI if they choose, correct? That part I'm not sure. Shout out to Amy for the sneak peeks with the 2-bomb, a super sticker. Thank you, Amy. Goodness. I already am a brat, Amy. The super brat. Shout out to Amy spoiling me. No verdict today, tomorrow, or Thursday, says RT. Shout out to Artie. I don't know. I give up. My prediction was Monday, so I don't get to make another prediction. 40 minutes to reach lunch. Bev said she's going to be back in 5 minutes. So while we wait, let's see what Proctor was saying. I want to hear these texts, man.
And there's a message there sent at 10:56 p.m. Is that correct?
Yes.
And who's that from?
A friend who lives in Tennessee.
And what does he say in that text?
I'm sure the owner of the house will receive some shit.
And you respond at 10:56 as well as 10:57. Is that correct?
Correct.
And what is it that you respond?
My first response was nope.
Thank you, Nikki.
Homeowner is a Boston cop too.
And
thanks for being here.
What, if anything, were you saying, or what was the purpose of that text in regard to the homeowner?
I was just letting him know that essentially Mr. O'Keefe is a Boston cop and the homeowner was a Boston cop as well.
Now, if I could turn your attention to 2533. And top of the page, sir, if you could read through that page as far as who's texting and what are they saying?
Again, for my friend from Tennessee and myself, I hope not, but I can't see it. I responded with, she waffled him. I looked at his body at the hospital.
Nasty.
He was banged up.
Now, as far as the next text from a 781 number, what does that say?
Did he get beat up?
And you responded to that, is that correct?
I did.
The objection sustained as to form.
What, if any, response did you provide to that?
Nope.
Objection. The objection was to the former question and the answer. Complete.
I'll strike it.
Thank you.
Now turning your attention to 2534. And from this page, sir, if you could again just read through as far as indicating to the jury who's speaking and what is being said.
You will, D. You will.
From the start of the first text, so the owner of the house.
Oh, no.
Yes.
So the owner of the house was a woman cop that beat him. That's what I initially thought after talking to Can paramedic. Then I saw the guy.
And those last two are your responses, is that correct?
Yes.
Now, the following text messages are from your friends, is that correct?
Yes.
What do they say?
Bear, let's focus. What does she waffle to mean? What's the story? I responded, she hit him with her car.
And the she that you're referring to there, who is that?
Miss Reed.
Look at this guy.
Now turning your attention to the next page, 2535. Again, if you could start at the top of the page and read through that page and just indicate to the jury who is talking and what is being said.
Okay. My friend in Tennessee states, okay, that's fucked up. I respond, intentional or not. Then another response, gotcha. He was frozen in the driveway and she didn't see him, question mark. That's another animal we won't be able to prove. And then I respond, they arrived at the house together, gone to an argument.
I don't want to speak out loud or out of turn.
The objection's overruled.
Your Honor,
But
if I could say this, there needs to be an identifier of who's
I
speaking.
understand what you think the mix-up is. So, Mr. Lally, go back.
Thank you.
Sir, if you could please, again, start at the top of the page and just indicate.
No,
as you go
just after the gotcha, he was frozen in the driveway, correct, Mr. Jackson?
That's correct, Your Honor. Thank you.
I respond, that's another animal we won't be able to prove. I follow that up. They arrived at the house together, got into an argument. She was driving and left. 781 number responds with, what's the name of the Canton cop living in Canton? The other one involved.
And how do you respond to that, sir?
There's several other messages before I issue a response.
Objection again. Bottom of the page.
So it's not an objection, but Mr. Lally, why don't you point him?
So, sir, at the bottom of page 2535, you have a response, is that correct?
Correct.
And what is that response?
They arrived at the house together, got into an argument. She was driving and left.
Objection.
So it's going to be a matter you can address on cross.
There has to be some accuracy. The reading.
So I understand. So, Mr. Lally, why don't you go point for your witness?
May I approach, Your Honor?
Yes.
Mm-hmm.
Oh, true. Yeah, no court on Thursday.
Okay. It's a HTML link, whiteout / Proctor iCloud / group chat Feb 2022. So you point out.
Can I see what you have for a second, please?
Yeah, sure.
Mr. Lally, it's on there. Why don't you go show your witness? Why don't you just read it, Mr. Lally, and tell us who you attribute it to?
Sure. So, sir, what I'm asking you about is the bottom of page 2535, excuse me, 2535. You indicated biffed him, correct?
Correct.
What did you mean by that?
That Miss Reed had struck Mr. O'Keefe with her vehicle.
Now, sir, if I could direct your attention to page 2537. Now, do you see a response toward the bottom of the page from yourself, January 29, 2022 at 11:04 p.m.?
Yes.
And can you read that response for the jury?
Yeah, but there'll be some serious charges brought on the girl.
And what did you mean by that, sir?
That throughout the course of the day, we had compelling evidence that Miss Reed struck Mr. O'Keefe with her vehicle.
Did you?
And you have 2 responses from friends, the same friends at the bottom of that page, 2537. Is that correct?
That's correct.
And what are those responses?
Keep your voice up loud, please, Trooper Proctor. Jurors can't hear you.
Yes, Your Honor. Number ending in 5051. Got to be. I can only imagine what internal affairs of the BPD are trying to get out there. And the second response, same number. She hot at least.
And turning your attention to the next page, 2538, at the top, if you could just read a series of responses from yourself, correct?
Yes, sir.
Read from those, sir.
Yep, so these came from me. From all accounts, he didn't do anything wrong. She's a whack job. CUNT.
Objection.
Say it. Say
So
the
don't
word.
spell it. You have to. So these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
Cunt.
Oh, they made him say it? Dang, this is savage. And he wasn't even fired yet. Oh, dang.
Objection.
So don't spell it. You have to. So these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
She said, man
Cunt.
up. Man up.
Yeah, she's a babe. Weird Fall River accent, though. No ass.
And, sir, what is it that you were referring to there, or why would you text that?
Why'd they say
These were,
that?
from all accounts, he didn't do anything wrong. Is talking about the homeowner, Mr. Albert. I had mentioned
Proctor.
the compelling evidence against Ms. Reed at this point indicated that Mr. Albert had nothing to do with Mr. O'Keefe's death. The rest of the unprofessional and regrettable comments are something I'm not proud of, and I shouldn't have wrote in a private or any type of setting.
Yeah. I think we all agree there.
At some point, if I could turn your attention to page 2540. And there's a photograph that's shared within this text communication, is that correct?
Yes, sir.
And does it indicate who shared that photograph? From the prior page, possibly.
Nasty, nasty.
The number
work.
ending in 5051.
And who is depicted in that photograph that was shared within the group text?
It's Miss Reed being escorted out of the State Police Milton Barracks.
And these are all from February 1st of 2022, around that time frame, is that correct?
Yes.
He said no way.
Now, sir, if I could direct you to page 2543. And, sir, if I could direct you to the top of the page and ask you to read through that page, indicating who's speaking and what the content of those communications are.
Okay. Number ending in 4146. Question, is that chick a smoke? Again, 4146, question mark. I respond, EH. I respond again, nutbag, as Chief would say.
Jeez,
I also
not
respond
bad, as
with,
Chief would
she's got a
say.
leaky balloon knot, leaks poo.
And what, if anything, is that in reference to?
Again,
Oh my God.
to Ms. Reed's some medical conditions there. Again, unprofessional comments I should not have made, and that I'm not proud of.
Why would they put this guy on the stand? Why did they do this? I don't get it. Oh, what a clown.
As far as attitudes expressed within these text messages and other text messages, what, if any, impact did that have as far as your investigation was concerned regarding this?
These juvenile, unprofessional comments have zero impact on the facts and the evidence and the integrity of this investigation. They said these are unprofessional comments, but they absolutely do not detract from the integrity of the investigation or the facts and evidence of it.
Your Honor, may I approach this
Sure
retreat?
about that?
Yes.
Now, Trooper Proctor, you've seen text messages amongst yourself and a variety of different people from that same sort of iCloud area of your personal phone, correct?
Correct.
And among those, are there communications that you had with members of the CAN police department?
Crazy.
Yes.
And how would you characterize, or what was the general
Text
content
messages did
of
cost him his
communications that
career.
you had with members of the Canton Police Department?
One communication was to coordinate interview times for firefighters and police officers and to set up a conference room where those interviews could be conducted. Obviously, the presence of Canton detectives or any police officers were not going to be sitting in on these interviews. Another communication was to inquire of relevant security videos that are in the area. Their local department, they know the area very well, so I reached out and asked if there's some good cameras in the area that I had of kind of interest in.
You may approach the witness.
Yes.
I'm showing you another document, just ask if you recognize that.
Yes, I do.
And what do you recognize that to be, sir?
Text communications between my sister and I.
That's your sister Courtney, is that correct?
That's correct.
And similar to what I'd asked you about the prior packet as far as a first message sent date and time, last message sent date and time, what is indicated on this first page?
First message sent date time, December 10th, 2021 at 9:33 p.m. Last message sent 8:30, 2022 at 8:48 p.m.
And 8:30, that's August 30th, is that correct?
I'm sorry, yes, August 30th, 2022.
And similarly to the other messages, is there an indication as far as how many number of messages were sent between yourself and your sister over that time period?
2,865.
And fair to say that the documents in front of you do not contain 2,865 messages?
Correct.
Now, just in reference to the first message on page 2662, the first page in this packet, do you see that from December 10th of 2021 at approximately 9:33 p.m.?
Yes.
And what does that indicate?
A text message from my sister.
And what does it say?
I called earlier, Dolph earlier, and Mom was puking in the background.
And do you recall what that was in regard to?
From the sounds of it, my mother had a stomach bug.
And sir, if I could direct your attention to page 2667.
I think after this we'll go to cross. Because I know this guy probably got.
And these are text messages from January 29th, 2022, between yourself and your sister Courtney, correct?
Correct.
And if you could read from the top of the page through the end.
Oh, y'all said, what did Beth say when she came back? Hold on. I want to make sure I didn't miss anything. I know y'all said they were going to lunch. Let's see. He said no way.
You do for ID? All right. All right, so we'll see everybody at 1:30.
All right, that's what y'all told me. Oh man. All right, we're gonna skip ahead to cross in a minute.
Then please indicate to the jury as far as who's talking and who's saying what.
So I texted my sister at work, "What's up?" She responds, "What? Why?" I respond, "I just found it frozen to death on a front lawn in Canton this morning. Actually just interviewed Jen McCabe. Said she knows you."
And they knows you, who are you referring to?
My sister.
And how did your sister respond to that?
Cut the shit. I responded, "You." It was a typo correction with my response to you. She responded, "Yeah, she knows Jack very well. She's really good friends with Julie." My sister continues on. Her sister is married to Brian Albert. My sister asks, "You still working?" ? I says, yeah, going to be out for a while. Homicide.
And as far as your answers to those questions, or as far as your communications that you have with your sister at this time, on the afternoon of January 29th, what were those in regard to, or why were you communicating that to your sister?
At that time, it was just kind of in the news. I was just kind of letting her know I was out working. She didn't share anything specific. I wouldn't share anything specific on cases with my family or anyone. It was just kind of an overall innocent conversation.
Now, turning your attention to the next page, 2669. Again, if you could read from that page as far as who was talking and what the content is.
All right. My sister starts off, the Can't thing is a homicide. I respond, this is at 3 in the afternoon on the 29th. Don't say a word to anyone. She said,
wait, is his sister an officer? What's going on? Why is he talking to his sister about this? Did I miss something?
of course not. I respond, in the very least, it's suspicious. She responds, this is your livelihood. And then I would never miss with that. 3:07, I respond, Julie and Chris were at the bar with the victim and girlfriend. Got to interview them.
Why was he talking about this with his sister?
I'd like to direct your attention to page 2672. These are messages from February 1st, 2022, is that correct?
Correct.
And the one at the top starts about February 1st, 5:57 p.m., is that correct?
Yes.
And again, if you could read through as far as who's speaking and what the content of those messages are.
I texted my sister, what's up? She responded, nothing. I just saw Julie, and she said, when this is all over, she wants to get you a thank you gift. And I respond, get Elizabeth one. Elizabeth's my wife. And my sister responds, because I guess her and Chris were friends with John, and she's so proud of you for leading this. And then she writes, Elizabeth, question mark? I respond with, she's been stuck with the kids for the last 10 nights. My sister responded with, yeah, but she knew what life is like married to a cop.
And sir, as
told
far
her to
as
suck
the
it up, huh?
gift that's mentioned as far as Julie Albert, is that anything that you have received at any point in time?
I never received a gift. I never asked for a gift. My wife never received a gift. She never asked for a gift.
So how would you describe this context of this conversation or why that's being discussed at this time?
Again, I don't know the thought process of my sister and Julie as far as bringing that idea of a gift into play. Like I said, I didn't ask for one. I never received one. The same with my wife.
Sir, if I could direct your attention to page 2676. And again, if I could ask you to start at the top of the page and read through and just indicate as far as who is saying, who is speaking and what they're talking about.
I start out, we write like 8 to 12 warrants on each case. My sister responded, no, I have no idea what the hell you do or how it works. I responded on the 10th at 7:36 p.m. I'm starving, but I also just want to go home. Thanks, though. My sister responds, yeah, but is dinner going to be waiting? She responded with, ha, ha, ha. And then I responded, yep. And then my sister responded with, okay, it's fine. Mom and I just don't want to go home.
May I approach, Ron?
Yes.
Mm-hmm.
These text messages are so bad. No wonder.
May I approach the witness, Ron?
Yes.
He's married, apparently. Yeah.
And another document, sir, do you recognize that?
Yes, I do.
And what do you recognize that?
This is private messages between my wife and I.
Again, what is your wife's name?
Elizabeth.
And what, if anything, does that indicate as far as dates and times and number of messages involved?
Okay, so the first message sent 5/20/2022 at 6:19 p.m. The last message sent 8/31/2022 at 9:16 p.m.
And what, if any, indication does it give as far as number of messages within that text chain?
1,632.
And of those 1,162, there's one message that's listed on that, is that correct?
Correct. And
what is the date and time of that message, and what does it say, and who's speaking?
This is me speaking on June 9th, 2022 at 4:56 p.m. I text my wife, waiting to lock this whack job up.
And what are you referring to in that text, sir?
I'm referring to the arrest after Ms. Reed was indicted by the grand jury.
Dang.
And again, as far as the terminology that you use in that text message to your wife, why is it?
Again, unprofessional messages I should not have sent. I don't have an explanation other than they're regrettable and it's something I'm not proud of, the language I used.
May I approach to retrieve your arm?
Yes.
Jeez.
All right, so Trooper Proctor, the jurors can't hear you. So speak directly into your microphone the way I'm doing, okay?
Yes, Your Honor.
This is going to be your last time on the stand as an officer, by the way. So you might as well make it good. Get it all out there, buddy. Waiting to lock this whack job up? Yeah, it's insane. And that's where the misconduct came from. Because what was he?
Maybe approach Johnson.
Okay.
Let's see. It was... He engaged in unsatisfactory performance, including sending sexist and crude text messages about Reed, providing case-sensitive details to unauthorized individuals, his sister, and consuming alcohol while on duty. What a whack job. He's the whack job. Terrible.
Thank you. Your Honor, may I approach the witness?
Yes.
You went on the document, sir. Before I get into that, though,
Thank you, B-dubs,
turn your attention back
for the
to
super chat.
some of the comments on the language used in the January 29th and February 1st or 2nd text communications among your friend group. With reference to that particular time frame in the language that you used, what sort of information had you gathered to that point, and why would you say or use that particular language in your, particularly in your descriptions of the defendant?
So this is, 16, 18 hours later, and we conducted multiple interviews.
Speak up.
Conducted multiple interviews. We knew Mr. O'Keefe never went into Fairview Road. We knew there was one shoe at the scene, one shoe at the hospital. Mr. O'Keefe's, based off Mr. O'Keefe's injuries, Miss Reed's statements when Sergeant Buchanan and I interviewed her, her broken taillight, the missing taillight, some taillight pieces found at the scene, the compelling evidence pointing directly at Miss Reed that she struck Mr. O'Keefe with her vehicle led me to make those comments. Whether, like I said, they weren't professional comments, but based on the day's investigation, it was clear that Miss Reed had struck Mr. O'Keefe with her vehicle.
Sir, if I could turn your attention to the documents before you, do you recognize those?
I do.
And as far as the participants in that particular conversation, who were the participants listed there?
It's Trooper David DeChico and myself.
And Trooper Chico and yourself both work within the same unit with the state police, is that correct?
That's correct.
And beyond the professional relationship you have with yourself, between yourself and Trooper DeChico, how would you characterize your relationship, generally speaking?
We're buddies, we golf together, hang outside of work, our kids play together, so I'd say, we're friends.
Now, within the, again, as far as the first message sent, date and time, and last message sent, date and time within this conversation, if you could describe that for the jury.
First message sent, date and time, March 17th, 2022, 11:08 a.m. Mm-hmm. Last message sent, date and time, August 18th, 2022, 6:08 a.m.
And again, the number of messages listed within this text chain.
87.
And fair to say the documents before you do not contain 87 text messages, correct?
That's correct, sir.
Now, just in general terms, if you have an opportunity to just look at the first couple pages there, fair to say those are just sort of jokes that you have going back and forth between yourself and Trooper Chico. Is that fair to say?
Yes.
Now, if I could turn your attention specifically to page 2632. And these are text messages starting on April 28, 2022 at 10:52 in the morning. Is that correct?
I'm sorry, what was the time again, sir?
April 28, 2022, 10:52 a.m.
Yes, correct.
And again, sir, with reference to this page, if you could read the content to the jury and please indicate whom is speaking at each respective time.
Thank you, Cynthia.
I start out without a doubt. He's got diarrhea of the mouth too. Trooper Chico, rookie move, not going into a meeting with the ME and getting that homicide determination. I respond, Yuri and I had 2 conference calls with her, sent her numerous photos, etc. We laid out the entire case for her. Trooper Chico responds, not good enough, should have had me or Jeff do it. I respond, if you two did it, she would have made it accidental or natural causes.
And can you explain the context of those communications, or what exactly is it that you and Trooper Chico are talking about in that communication?
Okay, so the ME is the medical examiner. They conducted the autopsy of Mr. O'Keefe. Our office, it's kind of a little bit of a locker room.
Hold on, wait for the ambulance, and then speak up. The jurors can't hear you way back where the court officer's standing.
Why she sounds so angry? Dang.
So like I said, the ME stands for medical examiner. They conducted the autopsy of Mr. O'Keefe. I guess I'll address the conference calls Sergeant Buchanan and I had with the medical examiner. The doctor had some questions as to the facts and evidence, kind of what had transpired, which is common. You know, even if it's a homicide, I've had many calls with the medical examiner's office. Even if it's a suicide or overdose, always with a homicide, the doctor wants to know. Myself, we kind of like to bust each other's chops, go back and forth. So that's what he meant by saying rookie move, not going into a meeting with the ME and getting that homicide determination. The original determination came back.
Sustained. Next question, Mr. Lowing.
Now, as far as attending the autopsy, is that something that typically someone within your office would do, within your unit would do with regard to any sort of death investigation?
Yes.
And do you know who attended the autopsy of Mr. O'Keefe in this specific case?
Trooper O'Keefe.
And so as far as Trooper Chico's reference to you not going in, or Sergeant Buchanan not going in, is that what you believe Trooper Chico was referring to in that message?
Objection.
Sustained as to the form.
You indicated that you and Trooper Chico bust each other's chops. Is that fair to say?
Yes.
And can you describe a little more, expound upon that as far as the nature of your relationship and sort of the text messages that you exchange in this and then other communications that you have?
Basically, just kind of needling each other, and him doing that is by saying, texting me, rookie move, not going into meeting with the medical examiner. So that's a perfect example of him kind of just needling me, which we do on a daily basis.
And as far as your interpretation of that, did you interpret that as a serious comment or something said in jest?
I interpreted that as a typical joke from Trooper Chico.
Now, may I approach to retrieve?
Yes.
May I approach, Your Honor?
Yes.
Showing you another document, asking, do you recognize that?
Yes.
Do you recognize that?
Text messages between myself and Trooper Chico.
And again, what is the first message sent, date and time, last message sent, date and time, and number of messages contained therein?
First message sent, date and time, April 28th, 2022 at 1:09 p.m. Last message sent, Date and time, April 28th, 2022, 4:45 p.m.
And the number of messages, sir?
4.
And if you could read the contents of those messages contained therein. Please indicate who's speaking.
So I started out, of course, it's undetermined. She was a whack job. Trooper Chico responds, "Dear God, WTF, what the hell is inconclusive about the whole thing?"
And as far as your indication there, as far as she was a whack job, who are you referring to there?
Ms. Reed.
Now, as far as the undetermined of what you're talking about, what is sort of the content or the context of this conversation?
That would be the manner of death was determined to be undetermined by the medical examiner's office.
And so I ask you again, as far as your reference there in the bottom of the first page, as far as she was a whack job, whom do you believe you're referring to there?
Again,
Ms. Reed or the medical examiner?
Ms. Reed.
May I approach, Your Honor?
Yes.
Your Honor, I'll take just a second to fill counsel. Your Honor, can you approach briefly on this packet?
May I approach the witness, Your Honor?
Yes.
We're handing you another set of documents. View those, look up when you're finished. Do you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
Another text thread between myself, Trooper DeChico, and Trooper Kokowski.
And Trooper Kaskowski is another trooper within your unit in the state police, is that correct?
Yes.
And again, if you could read from the first message sent, date and time, and the last message sent, date and time.
First message sent, date and time, 5/24/2022, 9:21 p.m. Last message sent, date and time, 8/24/2022, 4:56 p.m.
And as far as the number of messages indicated within this text chain between yourself, Trooper Kakowski, and Trooper DeChico,
494.
fair to say the documents before you do not contain 494 text messages, correct?
Correct.
Just in reference to that first page 2635, first message sent, that's May 24th, 2022, around 9:21 p.m., is that correct?
Yes.
And that's a message sent from Trooper Kaskowski, is that correct?
Correct.
And what is that?
Appears to be a picture of a toy Santa Claus.
Now, sir, if I could direct your attention to page 2644. If I could direct you to the bottom of the page, sir, you see the text from yourself at June 9th, 2022 at 11:19 p.m.
Yes.
Very bottom of the page. And, Your Honor, may I approach this and point it out?
Yes.
Yeah, I see it, sir. Okay.
If you could read what you wrote on June 9th, 2022, around that time, sir.
If you like women who shit themselves.
And again, sir, what is it that you're referring to there?
Again, a regrettable comment I made about Miss Reed's medical condition.
Now, if I could direct you to the following page, 2645. And again, if you could read from that page as far as who is, and indicate to the jury who is speaking and what is being said on page 2645.
I'm speaking right now. The statement she made tonight at 8/7 was mental. Thank Christ it was on BWC, which is body worn camera. Trooper Kakowski responds, "That's her. Smoke." Trooper Kakowski again, what'd she say? I respond, said the Alberts beat the shit out of O'Keefe, left him for dead, and that's why her taillight was cracked. She's gross. Trooper DeChico, oh, fuck her, bitch.
Thank you, sir. May I approach to retrieve, Your Honor?
Yes.
And sir, with reference to that last bit as far as June 9th, 2022, what was going on that day in reference to this matter again?
Miss Reed was being processed at the Milton Barracks.
Thank you. If I may have just a moment, Your Honor.
Yes.
May I approach?
Yes.
Can we do another set of documents to recognize those?
I do.
What do you recognize those to be?
Another text thread with members from my office, troopers.
And who are the troopers that are listed within that?
Trooper Chris Moore, Trooper Jeff Kakowski, Lieutenant John Fanning, Trooper Dave DeChico, and Sergeant Yuri Buchanan.
And what is the first message sent, date and time?
That would be 5/26/2022 at 8:19 p.m. Last message sent, date and time, 8/26/2022, 5:36 p.m.
And what is listed as far as the number of messages within this chain?
651.
And it's fair to say the documents before you do not contain all 651 of those messages within this chain, is that correct?
Correct.
Now, Sir, if I could direct your attention to page 2682. You see a message sent from Trooper DeChico on August 17th, 2022 at 9:42 p.m.
Yes.
And is that an image contained on the next page, which is 2683?
Yes, it is.
And what is the image of?
That is a picture of Mr. Yannetti. Appears to be from quite some time ago.
Now turning your attention to the next page, 2684. And there's a response from you, August 17th, 2022 at 9:44 p.m. Is that correct?
Sorry, sir. Go with the date and time again, please.
Sure. Page 2684, 8/17/2022, 9:44 p.m.
Yes.
You see there's like sort of three responses from you?
I have you now.
If you could just read the three responses from yourself, sir.
Okay, so these came from me. Funny, I'm going through his retarded client's phone. No nude so far. I hate that man. I truly hate him.
Now, with reference to the investigation at this point, when you're talking about his client's phone, who are you referring to?
Miss Reed.
And with regards to the phone at that point, can you describe for the jury sort of what's going on during this time period of August 17th, 2022 in regard to Ms. Reed's phone?
So after obtaining a search warrant for Miss Reed's phone, we weren't able to extract any data from it until August of 2023. Troopers in my office knew I was going through the phone that evening. I was most interested in location data, text messages, Google searches. That was the update I gave the troopers in the office. It was a distasteful joke. I should have gave a proper update instead of that. I wasn't able to go through the phone as thoroughly as possible because I came across some a text between an attorney and Miss Reed, so I had to stop going through her phone, and it made my supervisors aware of those communications.
Now, just in reference to what you had just said, this is in August of 2022, is that correct?
Correct.
So after a search warrant is obtained for the defendant's phone, where did it go? You indicated you gave it to Trooper Garino, and where did it go from there?
Trooper Garino essentially hooks it up to a device called Grey Key, where he tries every possible combination passcodes in order to access the data contained in the phone.
And at that time, when you retrieved it pursuant to the search warrant, you didn't have the passcode to the defendant's phone, is that correct?
Correct.
So that device is designed to sort of go through numbers and try to find a combination to get into the phone, correct?
Correct.
And so from the time that you had seized it in late January or on January 29th, 2022, until this date in August of 2022, had you been able to get into the phone or see anything in the phone in those intervening months or 7 months between January and August?
No.
And so then at this time that you're sending this text message in August of 2022, is that around the time that you were first able to access the phone?
Objection.
I'll allow it.
Yes, that was the first time we were able to have access to the phone.
And with reference to your access to the phone, were you looking for nudes or anything like that in regard to the defendant?
Objection.
I'll allow it.
Like I stated, I was most interested in Miss Reed's location data, text communications, Google searches, things of that nature. More evidence contained within the phone.
And so, sir, you mentioned at some point you came across some information that caused you to sort of freeze your looking through the phone. Is that correct?
Yes.
And so as far as that specific time period in August of 2022, when was the next time that you or any troopers from your office were able to actually look at any extraction of the defendant's phone?
So once I came across that text communication that took place on the 29th between Ms. Reed and an attorney, the phone had to be sent off to what they call a taint team to remove any attorney-client privilege information from the phone, and then it would be returned to us as well as defense received a copy of that as well. I'm not positive on the time. It was quite a long turnaround for that process to be completed.
Sometime at least in the spring or summer of 2023. Does that sound about right?
That sounds about right.
May I approach the retrieve, Your Honor?
Yes.
May I have one moment, Your Honor?
Yes.
Thank you, sir. I have no further questions, Your Honor.
All right, so I'm going to see you at sidebar so I don't interrupt your cross.
Trooper Proctor, in the summer of 2022, August 17th specifically, you were sitting at your desk, presumably alone at your office, at about 10 p.m. at night, going through my client's personal cell phone, correct?
Yes, sir.
As a matter of fact, you were sitting there texting with your friends and colleagues at Massachusetts State Police about you going through her personal cell phone. Is that right?
Correct, sir.
And that included Trooper DeChico, is that right?
DeChico, yes, sir.
Trooper Fanning, Trooper Buchnick, Trooper Moore, and Trooper Kotskowski.
Kakowski.
Tell me that again?
Kakowski.
Kakowski.
Yes, sir.
All right, all the consonants are silent. Fair enough. Trooper Fanning and Trooper Buchnick are your supervisors.
Yes.
And you were bragging to all 5 of them that you were going through Karen Reed's cell phone about 9:45 at night.
Objection.
I'll allow it.
Is that right?
No, I wasn't bragging, sir.
How did you refer to Ms. Reed in that text exchange where you informed them that you were going through her phone?
I used regrettable language. I said going through his retarded client's phone right now.
You were shown a photograph of my colleague, Mr. Unetti, correct?
Yes.
May I approach?
Yes.
Same document. I need a copy. Oh, Your Honor, I think the court has the copy that I was going to use.
I thought I gave him back to you.
Thanks. You'd received a photograph. Actually, Your Honor, if I could, I would ask that this document be marked as next in order. Assuming the witness verifies its authenticity.
So go ahead.
Do you recognize this document?
I do, sir.
Same document that you were shown, copy of the same document that you were shown by Mr. Unetti, correct?
Still Lally.
I've done that twice. Mr. Lally.
Correct.
All right. Is that a true and accurate reflection of the text messages that you were exchanging with Chris Moore, Jeff Kakowski, John Fanning, Vito DeChico, and Yuri Buchanan?
Yes.
I've asked that this be marked.
Okay, any objection?
Yes, Your Honor.
All right, I'll see you at sidebar. May I have that, please?
Yes, ma'am.
Your investigation as a professional, correct?
Yes, sir.
As an unbiased, objective investigator, the person that you were investigating, you referred to your bosses as retarded, correct?
Again, poor language on my part.
Poor language is one way to put it. Completely offensive is another way to put it, right?
Objection.
I've got to sustain that, Mr. Jackson.
After you referred to my client as retarded, then you decided to make a comment about Mr. Unetti, her lawyer, correct?
Correct.
And what did you say about Mr. Unetti again?
I hate that man. I truly hate that man.
I hate that man. I truly hate him, correct?
Correct.
You didn't say I dislike him, I disagree with him. You said I hate him, correct?
Correct, sir.
That's a visceral response to someone who's just doing a job, correct?
Objection.
Sustained. You can ask it differently.
Sure. Let me ask it this way. Were you upset or annoyed or pissed off that Karen Reed had gotten representation, legal representation, to represent her?
No, not at all. That's her right.
Well, let me ask you this. In August of 2022, you said you absolutely hate it, correct?
I don't know if I used absolutely. Yeah, I didn't use absolutely, sir.
You used truly, correct?
Truly, yes.
How do you feel about it now? You're sitting right there.
I still don't care for him, no.
I'll let it stand.
What did you tell your colleagues that you were looking for as you sat at almost 10 p.m. at night on a Wednesday night, August 17th, 2022, looking through Karen Reed's phone?
I didn't tell them I was looking through anything. They knew I was going through Miss Reed's phone. I provided a inappropriate joke as an update. They knew I was going through location data, text messages, Google searches. But like I had mentioned earlier, I had to stop.
Except Trooper Proctor, none of that really professional sounding stuff ended up in your comments to your bosses, did it?
Again, it was a poor joke.
Is that yes or no?
They did not know.
It did not.
No,
As a
sir.
matter of fact, what did you write after you talked about going through the, quote, retarded client's phone?
Objection.
I'll allow it.
No nude so far.
No nudes so far, correct?
Correct.
And you said that to your bosses.
Yes, sir.
You were looking for naked photographs of Miss Reed on a Wednesday night as you sat in your office at 9:44 p.m., correct?
No, not correct.
Let me ask you a question. Have you ever looked for naked photos of a male suspect that you were investigating?
I don't look for naked photos on anyone's phones.
But you said you were looking for nudes of Miss Reed.
Like I said, Mr. Jackson, it was an inappropriate joke.
Sir, this is a citizen. She's a woman. You were supposed to be objectively investigating. Does your text message to your colleagues at Massachusetts State Police reflect an objective investigation of a citizen?
Objection.
You can get part of that question and ask it again.
Do you believe that your text messages were reflective of an objective investigator?
Objection.
I'll allow that. Do you believe that, Trooper Proctor?
I believe poor jokes have, in unprofessional language, have no bearing on the integrity and the facts and physical evidence of this case.
It's not that they don't have any bearing on the facts and integrity. It's that they have no place in a professional investigation because it shows bias, right?
Objection.
So I have to sustain that as asked. Go ahead and ask it differently, Mr. Jackson.
You weren't so much as objectively investigating Karen Reed as objectifying her, correct?
Objection.
I'll allow that.
Isn't that right?
Rephrase the question, please.
You weren't so much as objectively investigating her as objectifying her in those moments, correct?
Again, Mr. Jackson, it was a poor choice of words and a joke that I should not have texted out. But from the start of the investigation, we didn't know what we had.
And your, Trooper Proctor, your point in saying no nudes so far to your colleagues in Massachusetts State Police was to suggest that you were looking for nudes and you'd update them when you found them, correct?
Incorrect.
Well, let me ask you a question. Did you find any nudes of
Again,
Karen Reed?
I didn't go through the photos, sir.
Did you find any nudes of Karen Reed?
I didn't go through the photos, sir.
You weren't successful in your quest.
I came across text messages from Miss Reed to another attorney on January 29th, so I had to stop looking through her phone.
So you got sidetracked before you could get to the naked pictures of Miss Reed. Is that what you're saying?
Sustained.
To be clear, when you sent those text messages on that group chat, those text messages included, as we said, or as you said, not one but two of your supervisors, correct?
Correct.
Were you ever reprimanded for your conduct in sending that text message?
Objection.
So that's sustained. Do we need to go to sidebar based on what you told me earlier?
We do not.
Okay, so...
I'll ask it a different way.
Okay.
Did either Trooper Fanning or Trooper Buchanan dress you down in a responsive text message in that text thread for doing something so abhorrent as looking for nudes or referring to nudes of a female suspect or subject of your investigation? Did that ever happen?
Not that I can recall.
As a matter of fact, in reference to one of the text messages in this same string, your boss, Yuri Buchanan, actually responded to the photo of Mr. Yannetti, didn't it?
Objection.
I'll allow it.
He did, sir.
After you received the photo, that's when you said, I'm, quote, funny, I'm going through his retarded client's phone. Is that right?
Objection.
I'll allow this, but not too many more.
Sure. Is that correct? It's on the top of page
Yes, sir.
685.
That's correct.
And Yuri Buchanan liked that comment. Funny, I'm going through his retarded client's phone. Didn't it?
I see you laughed at an image here, sir. I can't tell if he liked that comment, sir.
May I approach?
Yes.
I don't know if it's just because it's faded or... Yeah, my copy's faded.
Top 2685. You can use my copy if that helps.
All right. Thank you.
What do you see on the top of that page?
That Sergeant Mechanic liked it.
Liked what?
The going through his retarded client's phone, sir.
May I approach?
Yes.
I'll take my copy.
There you go.
So your supervisors at Massachusetts State Police not only didn't ride you for making comments like this, encouraged it.
Objection.
Sustained.
Trooper Proctor, this is your direct chain of command. Is that right? You're a Buchanan?
Yes, sir.
Did you believe that your conduct was a misuse of your
Y'all were
authority and
lying
power?
about Proctor getting cooked. I mean, this is bad. Can y'all still hear me? Can y'all hear me and see me okay? Hold on a second. There we go.
As you were going through her phone in August of 2022?
Objection.
I'll allow it.
No, I had a warrant
embarrassing.
signed by a district clerk, Stoughton district clerk, to go through Ms. Reed's phone. I don't think it was an abuse of power. I had every right to go through that phone.
Did the warrant say anything about looking for nudes of my client?
Objection.
Did it
No,
say anything about that?
No, Your Honor.
Okay, next question.
So that would be an abuse of the power that was given to you by the court, correct?
Objection.
Sustained.
Trooper Proctor, you'd agree that the hallmark of any good investigation, as you've been taught and others in Massachusetts State Police have been taught, is that the investigation and the investigator have to be fair. They have to be impartial. Would you agree with that?
Yes, sir.
Meaning that the investigation has to be free of conflicts, right?
Yes, sir.
The investigator has to be free of conflicts, right?
Yes.
The investigation has to be free of bias. Is that right?
Correct.
You can't be biased against the person that you're investigating. That would compromise the entire thing, wouldn't it?
Yes.
Basically, you follow the evidence. You're supposed to follow the evidence wherever it takes you, right?
Correct.
Good or bad, top to bottom, just follow the evidence and report it back. That's how an investigation is supposed to be run, isn't it?
Yes, sir.
And these are things that you learn early on at Massachusetts State Police Academy and then in your detective training. Isn't that right?
It is.
Literally, it's part of an oath that you took at the academy that you will, quote, faithfully and impartially discharge and perform all of the duties incumbent on you as a Massachusetts State Police trooper, right?
Yes, sir.
You swore that oath.
I did.
When you start an investigation, everybody in that investigation should be treated exactly the same. Don't you believe that's true?
Correct.
Everybody, have you ever heard the phrase, everybody's a suspect until they're not? Right?
Objection.
Sustained.
He already answered it.
It's especially important early in an investigation, before all of the facts are known, that the investigator is not compromised by bias, prejudice, right?
Correct.
Most important early in the investigation, because that's when the most things are up in the air. There's the cloud, the fog of not knowing exactly what the truth is, right?
Objection.
Sustained.
In other words, Trooper Proctor, you don't get to pick a suspect and then try to find evidence to support your choice, right?
Correct.
But in this case, it's exactly what you did, isn't it?
Absolutely not.
All right, Mr. Jackson, why don't we end for today?
This is as good a place as any. Thank you.
Okay.
All right. All right, so folks, we're off tomorrow. Those same
All right, what do y'all think, man? About Proctor getting cooked? We still have more time. We still have more video of Proctor getting cooked the next day, too. We'll get into that in a second. I want to acknowledge a couple of y'all who sent in some super chats and showed some love. We've got B-Dubs in here, says, paying my Proctor ugly. Some of the ladies said he was attractive. I mean, hey, I don't know. Yeah, I don't know. Also, we've got Cynthia Hartz in here with the 5 bomb, says, I love this group, my extended family. Thank you, Cynthia. Appreciate you being here, and thank you for the super chat as well. All right, if y'all are ready, we're going to go ahead and get into the next day when Proctor came back. This is going to be fun.
Yes, sir.
All right, whenever you're ready, Mr. Jackson.
Your Honor, as a matter of housekeeping, I would move to admit the packet of text messages with bait stamps inclusive of 02680, 02685 that was referred to on Monday.
Is there an objection to the written one coming in?
Same objection, Your Honor.
Why don't I see you at sidebar on this?
No, they are not back from lunch yet, by the way. Just a quick update. They're not back yet. Not that I can see, and I haven't seen any updates from some people who are in the courtroom too. So we're just going to stay here a little bit longer. We'll do a little bit more of Proctor's testimony, and then I think we might actually get out of here.
iOS message set of, may I, Your Honor? May I, Your Honor?
Yes.
One more matter of housekeeping. I have another set of iOS messages that are inclusive of pages 2527 through 2545. I'd like to have these marked as for identification as next in order.
All right, if you have any others, let's have them all marked for identification at the same time.
Your Honor, may I stand at counsel table to
sure.
deal with this?
And let's try and do it quickly. It's just for Mr. Jackson, let's try and do it quickly. It's just for identification.
Yes, these are all just for identification.
Yep.
I'll give the court the inclusive bait stamp numbers. Next packet.
Yeah, we don't care about that. We want to get back to this roast session. Let's go bed.
Proctor, I'm going to ask.
Here we go.
Thank you. All right, go right ahead, Mr.
Thank you, Your Honor.
Jackson.
Trooper Proctor, I'm going to ask you if you wouldn't mind to turn to tab 2 in the binder in front of you.
Here we go.
Can you take a look at the face page of what's under tab 2 and tell me if you recognize that?
Yes, sir. It's a private text thread with high school friends.
And this includes 9 participants, 9 chat participants that you engaged with?
That's correct.
Those participants include people by the name of Bird, Whitey, and Doc, correct?
Correct.
And then there's some other folks in there that are identified by at least the last 4 digits of their phone number, correct?
Yes.
So this is a group text or a group chat with you and 8 of your high school friends about this investigation.
Oh,
correct?
interesting, Don. Thank you for that insight.
Trooper Proctor, you never thought when you were engaged with these other 8 individuals that this particular set of chats would ever become public, did you?
No, I do not.
I want to take a look at page 2527, if you could turn, that's on the bottom right of the document in tab 2. Do you recognize, do you have that page in front of you?
Yes, sir.
You recognize that this group chat was taking place on January 29th at about 10:52 p.m., correct?
Correct.
And the person that I'll identify as 5051, that's the last 4 digits of that phone number, indicates Chip, name of that BPD cop, correct?
Correct.
First of all, you indicated on Monday that you're Chip, is that right?
Yes, sir.
You responded at 10:53 p.m., John O'Keefe, is that right?
Yes, sir.
So you were willing to tell, just a few hours into an investigation of the death of a Boston police officer, you were willing to tell a bunch of high school buddies details about the investigation, including the name of the victim, correct?
At this point, it's 16 hours later, sir. Not a few.
16 is a few hours, correct? I'm not talking about days later.
It was about 16 hours later, sir.
Correct. And you identified John O'Keefe as the Boston police officer who is fallen in the yard at 34 Fairview, correct?
Correct.
You also informed, if you will skip to page 2529, you also informed these same folks, these same high school buddies that, quote, all the powers that be want answers ASAP, correct?
Yes.
You knew, Trooper Proctor, that there was brass that wanted this case wrapped up quickly and efficiently. Isn't that right?
Objection.
I'll allow that. Is that what you were thinking?
No, the people wanted answers, sir.
They didn't just want answers. They wanted answers ASAP. What does ASAP mean?
That's as soon as possible.
Right. And you were texting this to your high school friends, again, 16 hours into this investigation, right?
Correct.
And you knew at that time, Trooper Proctor, that this was not going to implicate in any way, shape, form, or fashion another cop, correct?
Correct.
In this text exchange, let's turn to 2532, actually. Do you have that in front of you?
I do.
In this text exchange at 10:56 p.m., your buddy Bird writes, "I'm sure the owners of the house will receive some shit." Correct?
Correct.
How did you take that to mean? Did you take that to mean that he could get in trouble?
Yeah, I'm not sure exactly what my friend was getting at.
Well, you had some idea.
Yeah, maybe.
Said the owners of the house isn't going to get any shit for this, right?
That's how I interpreted it.
Yeah, you interpreted it like he's not going to get in any trouble. He's not going to be a suspect, correct?
Correct.
And he's not going to be implicated in any way. Is that right?
Correct.
And your answer was one word, correct?
Yes.
What was that word?
Nope.
And then you followed that up with an explanation as to why you said no, didn't you?
That wasn't the explanation why I said nope. I simply said homeowner is a Boston cop too, meaning Mr. O'Keefe was a Boston cop. The homeowner was a Boston cop as well.
The question that preceded your answer, nope, the homeowner's a Boston cop too, was the homeowner's going to get some shit for this, correct?
That's not what I meant with that text.
That's what you wrote.
Not what I meant, sir.
All right, let's take it in order. Question. Oh goodness, the homeowner's going to get some shit for this. Answer, nope. Next text, he's a Boston cop too. That doesn't sound like an explanation for your nope.
No, that's just saying he's a Boston cop as well. Mr. O'Keefe is a Boston cop.
And that's why he's not going to get any shit. Correct, Trooper Proctor?
That's what it sounds like.
Well, he's not going to receive any shit, sir, because Mr. Albert, the homeowner, had nothing to do with Mr. O'Keefe's death.
And you knew this 16 hours into your investigation.
Yes.
Less than a day.
Yes.
To your satisfaction.
To my satisfaction and
you
to the
hadn't
members
been
of my
to the
unit.
crime scene?
So let him finish. We didn't get the finish your answer.
To my satisfaction and to all the members of my unit who investigated that day.
Objection. Calls for speculation.
So I'm going to let it stand. Trooper Proctor, you have to keep your voice up, okay? Jurors need to hear you way back there.
Speak up.
Yes, ma'am.
Speak up.
The fact of the matter is, you hadn't been to the crime scene by the time you wrote this text, correct?
Correct.
You hadn't been inside the home, correct?
No.
You had you had questioned a grand total of 3 percipient witnesses at this point, correct?
Yes.
And 2 of the 3 were named McCabe, right?
Correct.
And 1 of the 3 was named Albert, correct?
Yes.
And it's against that backdrop that you wrote, nope, the homeowner's not going to get any shit because he's a cop, right?
It's not what I meant by that.
At 10:57, Bird goes on to write, he, the homeowner, must have been a puddle to accomplish that. And then he writes, who's the homeowner? And then he writes, I hope not, but I can see it. Correct?
These text messages are crazy.
Yes.
A puddle
Where would
means
we be
drunk,
without the
correct?
text?
That's a term for it, yes.
In other words, Bird wrote that the homeowner must have been so drunk, so wasted to have killed him. Correct?
Objection.
Do you know what that means? Do you know what that text means?
Just the puddle part, Your Honor. That term.
All right, so he can answer that.
And the puddle part means drunk or wasted, right?
Yes.
And what Bird actually wrote was, he must have been a puddle to accomplish that. Correct?
That's what he wrote.
And then you write back, quote, she waffled him. I looked at his body at the hospital, right?
Correct.
You used the phrase waffled about a Boston police officer
Crazy.
who had fallen in the snow and died in someone's yard. And you decided to use the word waffled him, correct?
Objection.
So sustained. Ask it differently, Mr. Jackson.
Did you answer, she waffled him, I looked at his body at the hospital?
I did answer that, yes.
And then Bird questioned, she waffled him, correct?
Yes.
And then you responded, he was banged up. Is that right?
Yes.
Then a person with the phone number 0095 wrote, I thought he was drunk. Did he get beat up? You see that?
I do.
And you wrote, nope. Is that right?
Correct.
Yet again, this is before 11 o'clock at night on January 29th,
Dang.
2022, some 16 hours into your investigation. Is that right?
Yes.
So before you ever went to the crime scene, before you ever went into the house,
Thank you, Jonathan.
only having interviewed 3 folks, you had this case nice and wrapped up, didn't you?
Yes, based on the evidence my office uncovered that day, the one shoe discovered at the scene, the one shoe at the hospital, Mr. O'Keefe's injuries,
that he said
the broken
yes.
taillight pieces underneath the snow.
Super Proctor, I didn't ask for an explanation. I asked, did you?
That's crazy that he said, wow.
In your mind, have this case wrapped up? Was it cut and dry in your mind?
Yes.
Yikes. This dude's garbage. All right. I know y'all want to get back into today's trial. Let's see what's going on here. They're back from lunch. Hopefully we have some clarity on what's going on.
Jim, can I have that question, please? Thank you. All right. So as counsel knows, we received a question from the jurors.
We've got another
If we
question.
find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're
Come on, jury.
not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The defense position is not certainly not the court should ignore it. I agree. We can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other questions, does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as
Yeah, me either.
as the court indicated.
This trial is crazy.
I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than 1 count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a
similar to the
later
first trial,
time,
apparently.
right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah. I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say, this question is not before the court.
It's also a dumb question.
Something like that. Not
Just
the
Google
court
it.
can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever
do you say?
those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer that.
So I don't know if I want to put you in an uncomfortable position. Ms. Giannetti, I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, Your Honor?
How about 1 minute? You guys are 10 minutes late.
We just need 1 minute. Thank you.
Keep those mics on. Hot mics, hot mics. I can't hear. We can't hear what they're saying. Oh, Aiden's finally back in there. All right, we should be 1 minute. Here we go. Here's our 1 minute.
Your Honor, just with a very slight tweak with the court's language, I don't have a principled objection to the court's language that we not answer the question at this time. I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was this is not a question I can answer for the reasons I stated.
Yes, it does,
it's theoretical,
Taco
and we
Tuesday.
tell jurors that they cannot be concerned with the consequences of their verdict, and that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah. I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict. So I think saying I can't answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns and it protects Ms. Reed's rights. I think that
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
If the court could add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
Hank is like, get me out of here. I don't blame him, man. Don't blame him at all.
I wouldn't allow the court to finish writing, but at this point, that is over our objection.
I understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights. I
Okay.
think this way it does.
Okay, it was a clear question that the defense first told me to ignore. So
I didn't
it's
tell
that.
you to ignore anything, Your Honor.
All right, we are all set. So let's send this in, please.
All rise.
Dang. There it is. No, don't say it's another mistrial again. I don't know if Karen can make it through another mistrial. I'd be done. I'd be out of the country. I'm not gonna lie. So you know what? America, greatest country on earth. It was fun. Check out Mexico, see what's going on down there, and good luck. I'll support the Karen Reed Mexico trip. Karen to Cancun. Jeez, man. So is she gonna bring the jury back in for this? Yeah, Amy said, what? Nah, Amy, we gone. I'm not doing 3 trials. I'm sorry. You gotta, taking everything and dropping it in Mexico. Or maybe find an island somewhere. I'm out. I can't do it. She's a witch. OMG. 3 short words. If there's another mistrial, it's all dumb as Ben's fault. I will watch the 3rd trial from Russia. Dang. As long as the people watching. This is crazy. So I think they're going to have to bring the jury in for this. Build it and they will come. What do y'all think this means? That question was interesting too. Some of you said, what did they ask? Let's run this back real quick. Here we go.
The jury, please. Thank you. All right. So as council knows, we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The defense position is not certainly not that you should ignore it. I agree. You can't ignore it to your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be
It is
appropriate to
BS.
send
I
them
agree.
a quick note, just asking them, given the fact that there's some clarity in your other questions.
Melody says, see y'all next
just answer
Tuesday.
your question.
No, no way.
Proceed without any further input by the court regarding that second question.
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm
Why
not
would they be
answering
hung
it?
up on the OUI though?
At some point, they
Thank you,
need to know what the
CPE.
law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than 1 count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a later time.
So the question is, Amy says, what's the actual question?
What are
Here we go. So the actual question is, here we go.
We received a question from the jurors. If we find not guilty on 2 charges, but
If we find not guilty on murder in the 2nd degree and leaving the scene of an accident resulting in death,
can't agree on 1 charge, is it a
and they can't agree on most likely the OUI because the timeline, right? Which is what they asked about earlier.
hung jury on all 3 charges or just 1 charge?
Will it be a hung jury on all of these or just hung on the manslaughter?
I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
Amy, what's your take on this? I'm about to call Amy. Amy, I want to know what you think. What are your thoughts on this? What do y'all think? Why are they asking this? Again, I use this as an example because this is what I can agree. It's so stupid that they wouldn't find. I'm not going to say stupid. Again, this is where juries get frustrating because you get hung up on something as I don't want to say simple. I don't want to say easy, as minuscule as this is in light of the entire case, right? They're like, murder? Nope. She didn't do it. Leaving the scene of an accident resulting in death? She didn't do it. But Jim and another juror are going back and forth on the timeline and the timing of the OUI, most likely, and trying to figure out if she's guilty of this lesser offense. And back and forth, back and forth. And he said, you know what? I'm not changing my mind. She's not guilty. Yeah, she was drinking, but we don't know what her blood alcohol content was, our blood alcohol level was. The other person says, I've seen enough. I know. They're like me. She's guilty. Ugh, what a mess.
The defense position is not certainly not for it.
And Amy says she's going to stick with what she told me earlier. Okay.
However,
they make it so hard for juries to clearly understand what they're doing on purpose.
Given the timing of when that question came in, literally before the court had answered the other 3 note card questions, I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other.
Let's see. So did she not bring the didn't bring the jury in for that to tell them that? Should though, right? See, we've already heard that 11 times.
I won't allow the court to finish writing, but at this point, that is over our objection.
I understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights.
Okay.
This way it does.
Okay, it was a clear question that the defense first told me to ignore. So
I didn't
it's
tell you
that.
to ignore anything, Your Honor.
All right, we are all set. So let's send this in, please.
All rise.
She said nope.
All right, we are all set. So let's send this in, please.
All rise.
Okay, so she's just going to send it back to him, it sounds like. Bev says she's responding with a note. Yep. Thank you, Jonathan. Jonathan Devereaux. I got to say his whole name. That's the dope name. Yep. A better listener than me. All right, guys, I'm good. I'm done. We got a couple more hours. Maybe. If they have a verdict, I will be here and we will react to it live. What a mess. What a mess, man. Let me shout out a couple of you amazing people who showed so much love during this live stream. We had a couple of super chats I need to get to as well. We had Karen here said, I'll be glad when this is over. This trial has been nothing short of a circus. Can't wait for the next trial on deck. Free Karen Reed. Thank you for the 5-bomb, Kara. We also had CPE in here with the 5-bomb as well. Said calling it since Auntie Bev decided to answer without answering. Not guilty on all counts. Karen can only hope. She can only hope. You would think that's the way they would go. They'd say, okay, well, we just have to find her not guilty. But it sounds like they're totally fine with being hung on that second count, which is insane. Amy in here with the 5-bomb says, if she was guilty, they wouldn't be worried about the other charges. It would just be guilty across the board. That's a great point. She's walking or mistrial / hung jury. Amy is so smart. That's a great point, and I have not heard it put that way. Because the manslaughter should be pretty easy. If she's guilty of the murder in the second degree, if she's guilty of leaving the scene of an accident resulting in death, then she has to be guilty of the manslaughter. Seems pretty straightforward. Amy says, I'm seeing people say it could be 30 minutes. We'll see. Those same people were probably saying they'll have a verdict on Friday. They don't know. I don't know either. It's just a guess. Oh my goodness. Oh, shout out to Renee says, I only discovered this channel last week, but I'm so glad I did. I'm glad you found this as well, y'all. We gonna get up out of here. If you haven't yet, y'all go eat some lunch, relax. We may have a verdict today. If we do, we'll be back. If you haven't yet, subscribe, hit the notification bell so you don't miss any time that we go live. Once there's a verdict, we might go live then, or we might go live outside of the normal morning show time. So if there is, make sure y'all hit the notification bell so you don't miss that, or when we drop a new video. All right, we're going to be back here. If there's no verdict today, I hope there is. If there's no verdict today, y'all know we'll be back here in the morning getting ready for another verdict watch. I appreciate y'all. Big shout out to everybody who contributed and went the extra mile and sent in some super chats. I appreciate y'all. We had Les Cleaver, my guy in the building, CPE, Kara Hampton, Slim Life, New Jersey, Virginia Wiley, Amanda Strong with her first super sticker as well. Dominique Carter, appreciate you. Ocean Grove, thank you, thank you. We got Vintage CB in the building. Curious Coco, New York. Brandy up in here. My dog Stephen G. Raunchy Dog, B-Dubs, Cynthia Hearts, and then of course my awesome, amazing Amy up in here, holding it down. Let me make sure I didn't miss anybody. Okay, we should be good. Again, we'll be back if there's a verdict. Y'all make sure you stay tuned. And as always, you know what to do. Keep growing, keep pushing, keep it classy. We gone. Peace. I hope they have a verdict today. This is amazing.